Ladyship's kind leave, my lord. But this pertains to, my lord, the Jalpaiguri Circuit Bench determination, my lord, this urgent writ petition. My lord, this was mentioned yesterday, my lord. I should indicate that before your ladyship, my lord. This pertains to, my lord, eking of out of livelihood, my lord, of the petitioners. This is a rice mill, my lord. Now, my lord, there is a policy by the central government to, my lord, redesignate or, my lord, the boundary has to be altered, my lord, in respect of, my lord, this particular Baksa Tiger Reserve, which is in the process, which has not yet been done. I had the consent to operate, my lord. In the meantime, my lord, I have been show caused. My unit has been closed down. A report was called for, my lord, by the Honorable Justice Joy Gupta while sitting in circuit, my lord. The report has been filed. The report indicates that, my lord, the authorities are ready and willing to abide by, my lord, whatever directions are passed by the Honorable Court, since the process is on and it is going to take some time. It is not within the jungle as of now, my lord. It's a running rice mill, my lord. It has been closed down. So, my lord, the report is already there on record, my lord. My lord, kindly, my lord, take it up.
You know, difficulty is
I completely
I have
appreciate, my lord.
refused Jalpaiguri matters to be enlisted because the file is required to be brought, and then again it will go back. It causes very difficulty. So this is the reason I refused. It will be there. The bench will be there. You please take steps. And once it has been refused yesterday,
It is my
today-
duty to indicate, my lord, that it is
sure,
mentioned.
and today if it is allowed, then a very wrong message
My
will
lord,
go
I
out
was
that the
humbly
court is not.
My lord, I was just humbly beseeching, my lord, if it can be taken up anytime next week, my lord.
No. You please go over there.
Very well.
Yes.
I'll do that, my lord.
My lord.
For inclusion the list lordship, that is motion. Case lordship was pending 2022 lordship.
I didn't get it.
That is pending as a motion 2022 lordship. There's a no list.
From motion?
Motion of case lordship.
Uh-huh.
After the direction of the court, there's one of the file a report lordship.
Right.
Lordship, matter is urgency lordship. The petition is the gun.
Where is the matter?
This matter is not listed lordship.
So you want inclusion?
Inclusion, lordship.
Come on the first Monday of the month. Yes.
Lordship, kindly.
Why?
Kindly.
Item number 300, 307 and 308.
Daily list?
Yes.
What is the matter?
The matter regarding the payment of the contractors.
I have refused all matters of similar nature.
The election matter, and two matters, petitioners.
Election matter? Which year?
307, 308.
Election matter of 2021?
Parliamentary election.
2021?
24 probably.
24, the latest. 21 matters payment have not been made.
Parliamentary and two matters regarding 298 and 300. Why I am mentioning these two petitioners are suffering a lot. Work has been done since 23 and the 24 already the payment is to be made, but it was not made.
Election matter can be upgraded because those matters are being taken up. But the other two, today I'll refuse. Come on the first Monday, I will allow. I allow all matters.
Similar pair, madam.
Hey, duto election matter.
308.
307, 308 upgraded.
I have similar prayer, madam. Monthly statement number 376, madam. I have rendered service, madam. My payment is due.
I have
There is
refused.
a cancer patient.
I have refused just now.
No, next Monday, madam.
Not next. If next Monday is the first Monday of the month, it is all right.
Lordship.
That I am praying for a leave, my lord, to move an urgent matter, my lord. My lord, in this matter, my lord, the district magistrate, my lord, quoted at the tender, my lord, for supply of kitchen devices. The petitioner participated, my lord. But, my lord, the technical bid of the petitioner has been, my lord, rejected on the ground that he has submitted the bank's debit advice as a credential certificate, my lord. And, my lord, the tendering authority, my lord, incorrectly construed my certificate submitted. It is a bank debit advice, but it is not a bank debit advice, my lord, on that ground, my lord. My lord, the financial bid has been opened on 18th day before yesterday, my lord.
Opened.
Yes, and
Yes.
they are going to issue the work contract.
What can be done now?
My lord, your lordship, next week, any date, my
No,
lord.
why? Because see, technical bid, you are out. Financial bid has been opened. Obviously, there must be a successful bidder, and the bid will be.
My lord, my credential certificate, my lord, has been rejected on the wrong ground, my lord. They have, my lord, wrongly.
I understand. You say it is wrong according to the authority. That is the proper ground.
No, my lord, they have construed it wrongly, my lord. It is,
Yes, it is your contention that it was wrongly construed.
my lord, we will satisfy your lordship, my lord, that they have wrongly construed. And my lord, the work contract has not yet been issued. Day before yesterday, the financial bid has
It will be issued. Somebody has turned out to be the successful bidder.
kindly consider, my lord. On 13, my lord, the technical bid has been rejected, my lord. And on 18th, my lord, the financial bid has been opened. So your lordship, any date, my lord, on the next week, my lord, any date, your lordship kindly consider, my lord. Otherwise,
I do not see any merits, far less urgency.
my lord, another points I have been taken that, my lord, the whose financial bid has been admitted, my lord. My lord, they have submitted the credential certificate, which is not valid certificate, my lord. Your lordship kindly consider, my lord. We have satisfied. We will satisfy your lordship, my lord. Your lordship kindly consider, my lord.
Next Wednesday come 26th.
But 7 matters are there, my lord. But
All same?
my lord, same, my lord. Only the tender number and the item is different. Otherwise, my lord, all same.
Tender number is different.
Tender
So the
number-
items will be different, the rejections will be different.
No, my lord, my lord, the who have been participated, they are same,
Participants may be same.
all same.
No, but then
Only
the items, the grounds for rejection, all will be different.
all same, my lords. Same credential certificate have been submitted.
All right.
The items, my lord, have been different.
Very well, serve.
Sir.
Ensure service.
Lordship's permission, Lordship, seeking leave, your Lordship. Lordship would recall on 13th of March, Lordship had passed a law.
Leave for what? Filing?
Indeed, your
Yes.
Lordship. Lordship, on 13th of March, your Lordship had taken up the matter where we wanted to conduct the Matua Mahamela, where your Lordship had directed, had given a reasonable opportunity for hearing, your Lordship. On 19th, within 19th, we had to
May I have leave, my lord, to take over, my lord. I appeared in this matter, my lord.
Hmm.
My lord, directed, my lord, a hearing, my lord, to be conducted by the my lord, additional district magistrate, my lord, of the Jilla Parishad. Now, yesterday was the date earmarked. Now, suddenly, my lord had directed also in the order that the ADM will consider the application which is on record as on date of passing of the order. Suddenly, we are met with a notice stating that the other faction, they again, my lord, have made another application on the 13th of March 2025. Now, my lord, we issue a notice of contempt that this is against the purport and tenor of the solemn order passed by the Honorable Court, because the court had categorically ordered that the order, that the application which was already there on record has to be considered. Now, thereafter, my lord, yesterday was the date earmarked. Now, my lord, the learned advocate representing, my lord, the petitioners, my lord, he was there along with the clients. Now, they suddenly say that no, there was another application also which was made to us, which was, my lord, never there in the report, my lord, that they filed. Now, thereafter, my lord, we find, my lord, the Honorable, the Chief Minister herself, my lord. Now, she has meddled in the affairs, my lord. She has suddenly, my lord, congratulated, my lord, the other faction for organizing the Mutua Mohamela even before, my lord, the hearing was conducted, my lord. So, my lord, verbally, they have said that no, we are not going to give you permission, because we have to give permission to them, my lord. My lord, this is the fact situation. My lord knows that the Mela will be
27th of
will be commencing from the 27th, my lord. Well, this is the fact situation, my lord. My lord, we are seeking for leave, my lord, seeking, my lord, judicial interdiction. My lord knows, my lord, the principles laid down, my lord.
Thing is,
My lord.
there is no bar in making application.
No, my lord's order categorically stated
Yes.
that the application which
are on
which are
record.
already on record.
Right.
So
That is
first,
all right.
my lord, the first dereliction is, my lord, yes.
But then, can you stop somebody else from making an application?
No, my lord, but
Possibly you
my lord, the
cannot.
question is otherwise, my lord. The question is, my lord, when there is a consideration pursuant to orders passed by the Honorable Court, whether, my lord, the authority can, my lord, transgress the, my lord, the conditions laid down in the solemn order and act, my lord, beyond, or, my lord, dehorse the, my lord, purport and tenor of the order. This is one. Second is, my lord, whether to side with, my lord, our case was, my lord, that this is the ruling faction, my lord, the faction, my lord, sided with, my lord, the ruling party of the state, my lord. Whether, my lord, documents can be generated, my lord, retrospectively, my lord, for the purpose of, my lord, granting them this particular favor. Now, this is the fact situation, my lord. They have verbally said.
Come up on Monday. Serve in the meantime.
Very well, my lord.
Lordship,
My lord, we are also taking up a contempt application, my lord, which we will be filing tomorrow, my lord.
Lordship, may I be permitted to mention one matter for upgradation, your Lordship?
Please don't mention. The month is coming to an end. First Monday of the next month. Please mention. I'll allow.
my lords can leave to mention on matter. This is against the demolition order passed by the subdivision magistrate. There was an earlier order passed by your lordship directing the executive engineer to consider my representation. That is pending. In the meantime, the subdivision magistrate suo motu passed an order of demolition, and the police
Under which law?
Lordship, the Highway Act, West Bengal Highway Act. Lordship, by day before yesterday, the police has came to my shop room and asked me to vacate within 3 days, otherwise it will be demolished. Lordship, I'll serve. Lordship, kindly take up this matter tomorrow. It is my only life.
You do not have any authority to stay over there.
No, Lordship, that's why your Lordship passed an order directing the executive engineer. My representation is there. There is an existing order passed by your Lordship. That representation
All
is still
said
under
and done.
consideration.
All said and done. Do you have any authority to conduct
No,
your
Lordship, there
business
was an
over the
observation
highway
passed
land?
by your Lordship that there must be alternative accommodation. That observation is there passed by your Lordship. That application is under consideration. In the meantime, this order came up. Lordship, kindly let me try my luck. Lordship, kindly take up this tomorrow. I'll serve notice.
Tomorrow?
They have given me 27 hours time. Day before yesterday I prepared the petition. Today I'm seeking your Lordship's leave.
Very difficult. Come on Monday.
Lordship, then Monday, Lordship, I'll indicate this.
Serve.
Contempt application for inclusion, Mela.
No, sorry. Yes.
Mr.
Yes.
There is a threat to invoke a bank guarantee arising out of a termination of contract note which is under challenge before this honorable court. But it's appearing in the list that we filed it as soon as we came to know of the termination order. During the pendency, we
Which list? Supplementary?
March 156
Monthly list?
1566.
Hmm.
I am constrained to mention this in view of the threat given during the pendency of the petition.
The petition is pending.
Pending.
Come on the first Monday of the next month. Let us see how much it can be upgraded.
To invoke the bank guarantee only if the application could be taken up. I have also filed an application to that effect.
Applications are taken up on Thursday. Are you aware who is appearing for your other side?
I can check it out. For the
Check up if you can get hold of your other side. Then today, when applications are taken up, please come.
Well, may I permit to mention item number 243, the supplementary list. This is a second round of litigation. First one, your lordship please to direct the authority concerned regarding the issuance of the nursing home license, which has been suspended from running the indoor operation, but the outdoor operation has been allowed. Considering that, my lord, my license has not been renewed till today on the ground, the title has been disputed by somebody else, which is not the subject matter of dispute, and the entire indoor facility has been stopped.
Item number?
243, my lord.
243, Wednesday. Next Wednesday.
As well, I'll
serve
notice.
Good. Item number 448.
243 of the daily list.
Daily list.
Daily list.
The Howrah Municipal Corporation, Lord, that contempt matter, employees, Lord, pension matter, Lord, your lordships granted leave on the last occasion, Lord, when I mentioned on Thursday that out of turn your lordship will take up, I will have to bring the other side. That Lord, the Mr. Siddiqui, now Lord, your lordship added Lord, the finance department as alleged contempt, Lord, principal. Now Lord, Mr. Siddiqui is appearing. Mr. Siddiqui requested me, since the Ramjan is going on, he used to leave the court Lord little early. If it can be Lord at 3 p.m.
No, 3 p.m. in the midst, it's not possible. Come at 2 p.m. in that case.
2 p.m. Grateful. Extremely grateful.
Which is the item number?
No, 448 and 449.
Today's list.
Today's list.
File টা বার করে রাখবেন।
Your lordship, may I be publicly mention one ordinal side matter. This is not in terms of the liberty granted by this bench of Chief Justice. You have not directed that I was given opportunity to file exhibit in opposition, and my lord, the petition was given opportunity to file exhibit in. So I have filed my opposition within the time. They have not filed their reply. So my lord, as per your lordship's convenience, any day it can be not taken up. Then it was my lord injuncted against which my lord I moved the honorable division.
Very well. To be mentioned, it will appear. Since the reply is not on record, you serve notice.
Yes, my lord, I already served the notice.
Next week, it will appear as to be mentioned.
My appear, my lord,
Oh, you're there.
my lord, I appear. My lord, we could not file the reply, my lord.
Right.
My lord, deponent or the my lord petitioner before your lordship, my lord has gone at kidney transplantation. My lord, he is confined at home for another 4 weeks. So if my lord, because they the trial court directed my lord, honorable single judge directed them to file their opposition by 2 weeks on 6th of August 2024. They did not file their opposition for so long. They preferred an appeal. Appeal was dismiss, your lordship sees the order of the appeal. My lord, there.
Whatever, let it appear. You make your submission. We'll see what is to be done.
My lord,
For my lord, 4 weeks time to file my reply.
Come.
my lord, may
The interim order in this matter is expiring on 28th of March 2025.
Give the number.
Madam, may I permit?
Serve notice.
My lord, may I permit to mention regarding the matter, this is a, after superannuation petitioner deposited the MI scheme.
What you want?
My lord, in regard,
Inclusion.
my lord,
Inclusion or upgradation?
upgradation, my lord. My lord, kindly MIS, no, not to pay any interest, my lord. Show the passbook, my lord. Kindly petition is very poor, my lord. After kindly must take the matters in interest.
Next week when mentioning is taken up, then come.
My lord, may I be permitted to mention the matter? My lord, I know it's, my lord, upgradation matter your lordship generally doesn't allow, but I cannot wait till the first Monday as because, my lord, these pertains to, my lord, the obstruction of an imambara by temporary structures, and this is the month of Ramzan, my lord, the devotees cannot offer their prayers. Now, my lord, we don't want to disturb
Who
anybody.
has constructed?
My lord, this is the temporary structures
Who has
conducted.
constructed?
My lord, various people has
Various
constructed.
people, you have not made anybody as private respondents or something
Yes,
of
yes, we
that
have
sort?
made them party. We have made them party.
So various people.
Yes, made them party, but the fact remains is, my lord, the district magistrate lordship will be aware under the King's Endowment Act 1911, the district magistrate is the custodian of the property. You only seek and leave, my lord, to clear the obstruction, nothing else. They are the other people also, my lord. This is the general Imambara pictures on general days, and this is, my lord, the obstructions. Even the rail grades of the police has been removed, and my lord, this entire place is, my lord, been obstructed. We only want an ingress and egress to the Imambara. They are also, my lord, they can also do their business because it's the month of Ramzan. They also have a right to earn their.
That means these are the stalls which have been set up possibly.
Yes. Only the ingress and egress. Lordship will find, my lord, this is the Imambara gate. This portion, my lord, there was a rail gate.
It falls under which municipality, panchayat, or
My lord, it falls under the Calcutta Municipality Act, but the under the King's Endowment Act of 1911.
no, who is the person to look into it? The DM.
District magistrate.
Where is this?
In, my lord, the Garden Reach. Because these falls
within
under
the KMC jurisdiction.
yes, KMC jurisdiction, but my lord, these falls under the Wajid Ali Shah estate. And Wajid Ali Shah estate is maintained and managed under the act by the district magistrate. And my lord, one matter I also had the pleasure of moving before your lordship, wherein lordship was pleased to direct the district magistrate to look into the affairs. We only want the ingress and egress to the Imambara during the month of Ramadan.
Tuesday it will appear, serve notice.
Grateful.
Give the number.
Grateful, my lord.
Number.
Yes.
My lord,
I have
in an urgent circumstances, I am saying before your lordship's kind leave to move this matter in an unlisted manner, my lord. The difficulty is, my lord, I have 2 cash credit account and 1 GSEL extension with the Punjab National Bank, my lord. Now the cash credit, I have sufficiently maintained the account, my lord, and give the EMI towards the GSEL extension. And the cash credit account has been renewed as on 1st of March 2025, my lord, to its limit. Suddenly, my lord, I have received one notice from the Punjab National Bank on 4th of March 2025, my lord, declaring that the account became an NPA and I have to pay the limit immediately, my lord. And after the NPA has been declared, my lord, I am not, my lord, I have a rice mill, my lord. I cannot, my lord, use the limit, my lord. My employees are, my lord, working there but I cannot give the resources to them, my lord. That is the most difficulty, my lord. And my lord, subsequently, my lord, they are trying to proceed with the SURFACE application as well because they have already invoked the section 13(2) of the SURFACE Act. And my lord, send a demand notice.
13(2) is there, 13(3)(a) is also there. Why don't you apply?
My lord, 13(3)(a) is also there, my lord.
Go and apply.
That is the SURFACE proceeding, my lord.
Then,
but as the recall notice has been sent on 4th of March 2025, my lord, by declaring the bank account as NP, I have challenged that before your and came before your lordship.
No, 13(2) is not under challenge. It cannot be done in this way.
No, not my lord. 13(2), my lord. I have challenged the recall notice, my lord, which was sent, my lord, declaring my account as NPA, my lord. That I have challenged, my lord, just because of one reason, my lord. As the account has been declared as NPA, I cannot use my resources, my lord, for my
Obviously, how will you
for
use?
my profession and for the right to life, my lord. That is
are
the
not
difficulty,
paying,
my lord.
you are not paying possibly the dues. There are dues
I-
of the bank. That
I
is the
have, my
reason.
lord. I have already. As on 1st of March 2025, my lord, my bank account
Very well.
statements is showing that.
Tuesday it will appear.
My lord,
Pardon, my
may I
lord?
mention, my lord,
Serve notice Tuesday.
may I
Grateful,
mention application for contempt, my lord.
No, sorry. Yes.
I need to make that for restoration application.
No.
My lord, I want to mention one item number 262 of the today's daily list. It is for the release of the item WPF 5316 of 2025. The matter is for the related to tender process. The petitioner Vidyut
You want the matter to be released?
yes.
Why?
The release yes sir ma'am, yes release I want to, yes I want to release no matter.
Why? What is the reason?
Reason
Yes.
My lord, I beg to mention one matter for release, my lord. This matter is, my lord, relates to, my lord, tender. The tender notice was issued by the BDO, my lord. This matter relates to Panchayat, my lord.
Panchayat matter? Which item?
Item number 1122 of the monthly list, my lord.
Serial number? 1122.
1122.
Very well. Released. Are you the advocate on record?
Yes, my lord.
Give your name.
My lord, may I
Released.
release I can
Why release? Why? You do not know the reason.
come to another matter? Matter was fixed for monthly list of July 2024 before the Honorable Justice.
Now from July till March it has come. It cannot be done. Call the list, please. The matter has appeared in the list for correction of the writ petition number recorded in the order dated 13th March 2025. Stop. The proper number is WPO 178/2025. The department is directed to make the necessary correction at once. Rest of the order remains unaltered.
Item number 2, I'm appearing for the petitioner, my lord. Lord, the original affidavit of service has been displayed. This is the Xerox. It has been served, my lord. Kind fillers.
If your other side is there, no issues. If
All-
it is not, fresh service. This is the. Let me see who are the respondents.
Respondent number
6 and
Damdam Municipality.
respondent number 6 and 7.
3 for the Damdam.
Damdam Municipality, State of West Bengal.
Lord, the state of West Bengal needs to be represented because the primary allegation is against the drug
Needs to
control.
be represented till you can show service. What
But
can
there
be
is-
done?
Lord,
Director of Drugs.
the
Director
service
of
is complete. I have the
Drugs.
Xerox. It contains the postal receipt as well as the tracking report, but not the original. That is the difficulty.
Did you serve the AOR's office?
Lord, the original
Advocate on record কি serve করেছে কি দেখুন তো?
এর মধ্যে নিচে দেখেছো কোথায় বলছি
করেনি না। You are for 6
and 7.
private
6 and 7.
Right.
Serve.
stuff again.
Please come. None appears on behalf of the state respondents. Stop. Let notice be served in the office of the advocate on record, intimating that the matter will appear in the list next Thursday, 27th.
My lord, there have been a subsequent development. May I bring on record that by virtue of a supplementary affidavit?
I
Because,
do not know what the matter is about.
my lord,
Subsequent
the-
development.
The matter has become infructuous since, my lord, he sought for a revocation of the license. And,
that
my
has
lord,
been revoked.
no.
we have already, my lord, surrendered the license and they have accepted the same.
So that is for the authorities to do. How am I supposed to know? Because I had made a complaint. What has happened? My lord, the authorities have so caused me.
See, देखिए ओटा एकটু.
My lord, this needs to be
This is
verified
a
by the
dispute,
authority
my
concerned.
lord, this is a
Because I-
dispute between the father and the, my lord, the daughter-in-law. And both are running, my lord, the two pharmacy. In the name of the Arya Medical, other is Arya Pharmacy.
Your challenge in the writ is
the
For
grant
the revocation of the license
grant
in
of
favor of the
license.
daughter-in-law.
to take
Gra-
immediate legal action, including revocation of the impugned license.
granted to the
Respondent number 6
Six.
and 7.
Yes, granted to them because it violates the mandate of the Drugs and Cosmetics Act.
Drug license. 752045. I, such and such, proprietor of such and such, carrying a property license being number such and such,
Completely family dispute.
and valid till at the due to
family.
person living, I am surrendering my original. It has been surrendered. Nothing remains in your writ petition.
If that is the case, nothing remains, but this needs to be verified by the authority, the drug control, to whom I have made the application under section 66.
All right. যেটা বললাম সেটা থাকবে।
I will serve and
Learned advocate representing the respondent numbers 6 and 7 submits upon instruction that the private respondents have already surrendered the original drug license, which the petitioner seeks to be revoked. Paragraph. Learned advocate representing the state respondents shall take instruction as to whether the subject drug license has been surrendered before the competent authority and whether the same has been accepted by the authority.
Madam, may I get a copy of this document?
Give a copy to him then.
Grateful, Your Lordship.
এটা তো এখানের হচ্ছে, এটা হচ্ছে কলকাতা 73, তো এখানের ভেতরে পড়বে। Director of Drugs, Kolkata 73 is here within the original site jurisdiction.
Let the copy be written with.
Copy of the ওইটা একটু রেখে দেবেন তো রেকর্ডে।
Matter is returnable on
Next Thursday.
next Thursday. Great.
Lord, I appear on behalf of the respondents.
Lord, I appear on behalf of the petitioner, my lord. My lord, I have suffered an injury and I'm not in a mobile position to attend the court for the next 2 weeks, my lord. Lord, I'm assisting Ms. Maharia, but since it's a hearing matter, my lord, if subject to convenience of Mr. Chatterjee, if the matter can be posted 2 weeks hence after.
They're trying to delay this. But my problem is that my instructions are that because Miller, it's 31st March, they are Miller members of the association and they want Miller the services of the association in that apartment ownership. So now GST has to be Miller put in and he's enjoying the services and he's paid nothing. In the meantime, Miller, let him pay whatever Miller is his due and enjoy the services, or we will have to Miller take away the services from him. Because showing the pendency, Miller, they are trying to take advantage of that. Your Lordship fixes it any day, Milord, but at least to that effect, Milord, kindly Milord protects us that they would pay the Milord the maintenance charges.
My lord, if I may kindly indicate, my lord, in an absence, I failed to pay before the association, my lord, I'll be treated as a defaulter. Now, no interim protection has been granted so far as my right to enjoyment over the property is concerned, my lord. There is no reflection in the order as of now, my lord.
All services are provided to him. He has a security.
Though we are enjoying, that is not in a disputed position, my lord. Though we are enjoying, my lord. My lord, there are other persons apart from the present petitioner who have been treated as a defaulter in furtherance of a notice newly issued at the behest of the purported association. My lord, the moot question which has to be decided whether this association has been validly constituted or not, and there are other issues also. My lord, till such time, another week, it's only for my personal difficulty. I don't think, my lord, Mr. Chatterjee will oppose on the ground of my personal.
No, I'm not opposing you. No. Please don't get me wrong. I'm not.
Thing is, are you required to pay for the services that you are enjoying or not? And if you want your name to be included in the list of defaulters, then that's something else.
My lord, I have already been treated as a defaulters under the new board, whom Mr. Chatterjee is representing presently.
This notice has been given. He hasn't been treated as a defaulter.
That is not under this.
Proceed in accordance with law. Whatever is there, you will do.
Very.
My lord, one more indulgence, if I may ask for, I'll communicate what has fallen from your lordship and as well as Mr. Chatterjee today in the hearing. Now, so without prejudice to my rights, if my client wishes to pay, then my client can. But my rights to challenge the association and the formation of the association be kept open, my lord.
Yes.
If that is the challenge in the writ, then that is always open. That is, nobody is stopping you from agitating that point. But as regards payment, the court is not recording any order. If you choose, you pay. If you don't pay. And the authority will take steps in accordance with law. The court is not recording anything. It's only the adjournment that's being recorded. Please come. Learned advocate for the petitioner is indisposed and seeks accommodation. Stop. In view of such prayer, the writ petition stands adjourned till 10th April 2025.
Grateful.
Lord, I am for the petition of My Lord, I beg to pay for the Reserve Bank of India.
Petition notice of নিচে আর উপরেটা এমনি normal service.
Serve the notice, my Lord.
What is the matter about?
My Lord, the matter is, my Lord, the petitioner number 1 is a widow of a person, my Lord, who died on 26th of November 2020. And my Lord, the other petitioners are her sons and daughters. Now, my Lord, before his death, my Lord, this deceased husband of the petitioner, my Lord, he invested in public provident fund. Now, my Lord, after his death, the widow, the petitioner number 1, my Lord, submitted an application, my Lord, before the bank, my Lord, that is, your Lordship will find at page 26. It was initially Allahabad Bank, now it is merged with Indian Bank. This is the prescribed application form. Kindly see application form for settlement of claim of deceased constituents for payments of balances in accounts, etc. Now, claim for payment of balances in the account and delivery of articles in safe deposit locker, safe custody of late Sri Subhash Mitra expired on 22nd of November 2020. We advise that Subhash Mitra expired on 22nd of November 2020. Then, my Lord, in the box, my Lord, your Lordship will find the PPF account reference number was given, account number, and the amount. Then the next page, my Lord, at the top, my Lord, your Lordship will find succession certificate issued on 28th of January 2021 that was submitted. And, my Lord, in the second box, in the middle, my Lord, your Lordship will find petitioner number 234, here applicant number 234, my Lord, they issued the letter for of disclaimer, my Lord, that they do not have any claim with regard to this payment. Now, the petitioner number 1 is, my Lord, Shivani Mitro. Then, my Lord, your Lordship will find this was at page 29, this was submitted on 13th of December 2022. Now, along with this, my Lord, the petitioner submitted, my Lord, the PAN card, Aadhaar card, all other documents, my Lord, including, my Lord, the income tax return, etc., my Lord, that I have annexed, and notarial affidavit, what the blank claimed.
What is the problem now?
Now, my Lord, 3 consecutive letters were issued. The first one, my Lord, before that, my Lord, I lodged an online complaint, my Lord, that is at page 78.
What is the complaint about? They are not giving.
They are not, my Lord, releasing the fund. One after another, I shall show, my Lord, they are, my Lord, raising issues. Initially, my Lord, the Chief General Manager raised 5 issues. Most of them are with regard to the bank officials' negligence. Then, my Lord, there are 3 issues. Now it has come down to 3 or 4 issues. I shall show, my Lord, page 78, your Lordship will find. In the last column, my Lord, your Lordship will find that the account will be credited in 5 days. This was issued on 18 November 2022. Thereafter, my Lord, the first letter we received, my Lord, at page 80.
Yes.
My Lord, on 17th August 2022, the Deputy General Manager, my Lord, wrote a letter to the branch manager. Now, he raised 7 issues. First one is claim form to be filled completely, copies of death certificate and KYC to be submitted after verification. Now, these are the issues. Then, my Lord, this has been complied with. Thereafter, my lord, at page 81, a further letter was issued on 17th September 2022. Here, your lordship will find some new issues were raised.
What is the last objection?
The last objection is at page 82. 19 December
22.
at page 82, my lord.
Yes, it's 2022.
2022, December 2022.
Balance in is such and such, the net worth of the sureties.
Proportionate with that of the claim amount, the balance sheet submitted prepared by the sureties is not even audited. Then 2, claim form to be signed by the branch manager under office use. This is not my duty, my lord. This has to be done by the branch manager. Annexure D to be signed by the branch.
Well, let me hear the bank. Who's for the
Reserve Bank of India?
Union Bank? Indian Bank?
My lord, only may only submit one thing. Perhaps the bank has not been made a party.
Indian Bank.
The bank has not been made a party. That is what appears from the copy of the petition.
My lord, no. Respond number 3, 4.
They are the officials, but the bank itself is not a party.
And respond number 5.
Did you serve 3, 4, and 5?
Yes, yes. Copy the phone. And then mail for intimate position. Office copy xerox করিস নি? My lord, may I give a further notice because
We have
their
to,
presence
otherwise,
is required, my lord. Yes.
without their
Very well.
and do one thing, you implicate the bank also, because
well.
these are the officials. The bank ought to have been made a
Kindly,
party.
my lord, grant me leave.
Please come. None represents the respondent numbers 3, 4, and 5 despite service. Let further notice be issued upon the non-appearing respondents, intimating that the matter will appear in the list next Thursday, 27th. Leave is also granted to the advocate on record of the petitioner to implead the Indian Bank as party respondent in the instant writ petition and serve a copy of the writ petition upon the added respondent. Affidavits of service filed in court is taken on record.
Grateful. My lord, let it remain, my lord.
It will be there as urgent motion.
Grateful.
Who is your other side?
Notice even after mentioning we have sub notice.
In the GP's office, state is the party or what?
State party and there is a private.
Private respondent also?
Private means, my lord, it's a federations of various trade unions.
For the?
For the state respondent. The petitioner here is a member of Directors Association of Eastern India. Now there is a federations of senior technicians and workers Eastern India. This FCTWEI is a federation of at least 25 trade unions of various technicians, makeup artists, floor artists, the dancers. These are combined. Now this FCTWEI now is controlled by someone, as a very politically influenced person who has no relations with the filmmaking. Now, time to time, various impositions have been made by this FCTWEI over the directors or the producers. They were compelled to hire more employees, more workers than what is required. They are compelled to hire. I have enumerated all these in paragraph 9. Kindly take paragraph 9. And you will also get the affiliates associations in paragraph 16. I read or you lost?
No, I can read it. Did you raise complaint?
Yes, yes. Now what happened, my lord? There was a lockdown. In fact, entire film industry was closed down for. Now the state government interfered. The Honorable Chief Minister interfered. My lord, he proposed that a committee would be constituted who will oversee the my lord, actions of this FCTWEI. But that was just it was reported in the newspapers. But the committee, the members of the committee have been named. My lord, those are Gautam Ghosh, the
No, but then does the committee have any legal existence?
because the state government didn't notify anything.
All right.
And that's why the
So-
company couldn't, Malad, cannot function.
True.
Now, what happens, Malad, in the meantime, virtually whoever defies this diktat of the FCTW, he is banned because the restrictions will be imposed on her. She or he will not be able to do any work. He will not be given the floors. He will not be. No cameraman will come. Malad, this is a wielding of power, Malad, uncontrolled power, Malad, which has virtually crippled the film industry. I am giving a data, Malad, I have affirmed a supplementary affidavit. More than 200 films, Malad, had gone into productions in 2016-17. It came down to 136 in 2023, and in 2024, when Malad, more impositions came, Malad, it came down to only 36. And in 2025, probably it will not be more than 25. Malad, now the renowned directors have faced, Malad, the Kaushik Ganguly have faced. One Rahul Mukherjee, he was banned for 3 months because he, Malad, tried to complete his film by utilizing the Malad workers of Bangladesh. He was banned. Now, what this, Malad, by this manner, virtually any independent director, Malad, he cannot work. His fundamental right to work has been curtailed by a federation who controls
Where
the
is
entire.
your complaint before the
Yes, now
authority?
kindly come to page 91. Before that, I have annexed, Malad, the formation of committee. Page 91 is my representation. This is there. Malad, in fact, I want to move these petitions in representative capacity after obtaining leave from of your lordship under Order 1, Rule 8. I have recently, Malad, even this petitioner is now prohibited from carrying out any works because of she filed these petitions. But it's a government obligation. Malad, I can cite 2-3 judgments. But it's a government obligations to ensure this, Malad, is maintained.
Page 91, has it been considered?
No response. No response.
State.
But what I am today is seeking, Malad, I will be beseeching your lordships, Malad, if your lordships, Malad, form a committee of retired judge or who will just submit a report before your lordship.
Let me hear the state first.
Lordship, we are very candid. The instructions I have received is that state has made certain endeavors because there was a complete lockdown and shutdown. There was no work going. State has made certain endeavors. After that, work has started. But following that, your lordship, because committee and everything has to be formed, there has to be some statute or statutory authority or something like that. There is no.
But why is the outsiders interfering with the work?
They are not outsiders.
Who are they?
They became the president of this FCT.
I cannot vouch for
Malad,
the private respondents. I cannot vouch, but they are the technicians.
Malad,
They are technicians. There is a problem with
No.
the-
Mr. Kaurav Bishwas is the president of this FCTWEI.
Who is he?
Malad, he is the influential leader of the political party, the brother of Minister Kaurav Bishwas.
That
Now he
allegation I
controls
cannot
everything.
I cannot defend any private individual. In my
No, I'm not.
there's no,
I'm not. But he
nobody is named in the petition, so I'm not going to that extent.
Because respondent number 5 has to whatever allegation, his basic allegation is against private respondent.
The respondent number.
State has made certain endeavors regarding, because after the endeavors made by state only, work has started functioning.
No, now it is again, Malad. If Malad, I'll just
You bring instructions in response to page 91. Have you followed?
Malad, only one thing, Malad, leave may be granted under Order 1, Rule 8 of the Code of Civil Procedure. Malad, I have asked for that leave in the supplementary affidavit, Malad. I have just
In the supplementary affidavit.
Leave be granted to file the supplementary affidavit also.
Is anybody else trying to move forward? Dekhi, let me see the application.
Yes, Malad, there are other directors, Malad. I have information that all will, Malad, many will come. Not only the directors, Malad, the producers will also come. Now the recent imposition is on Kaushik Ganguly. Then one has to, my lord, if anybody defies, my lord, he has to made a, my lord, he has to pray for forgiveness by a video recording and it is to be posted in the social media. Otherwise, he'll be stopped from working from the day one. This is the scenario is going on. And everything will come forward if your lordship forms an independent committee or special officers, my lord, will submit a report. He will, my lord, give this report. If your lordship go through these allegations in paragraph 9, those are all on record. And they issued code of conduct, this FCTWEI. They issued regulations, my lord, which I have annexed. It says nobody can work unless they give permissions. My lord, no film can be.
All right, I'm keeping this on record. Let him bring instructions with regard to page 91. I'll see.
And they leave under order 1 rule 8, my lord.
Supplementary affidavit filed by the petitioner is taken on record.
Okay,
Stop.
copy
Copy of the same handed over to the learned advocate appearing for the state in court today. Stop. None represents the respondent number 5. Despite service, affidavits of service filed in court is taken on record. Stop. The petitioner alleges high-handedness on the part of the respondent number 5 in not allowing the petitioner and similarly placed members of the
DAE, Director Association of Eastern India.
Director Association of Eastern India to perform their work independently. Stop. A complaint was lodged before the respondent authorities in January 2025. Stop. The same is alleged to be kept pending. Paragraph. Leave has been sought for. You make an application for moving it in the representative.
It can be sought for under order 1 rule 8.
Yes, but isn't an application?
That prayer is in their supplementary affidavit, paragraph 7.
By way of an affidavit, you cannot make a prayer.
This can be asked for by oral prayer even. But there is no requirement as such. I am seeking a leave at my own to move it in representative capacity. Kindly go through order 1 rule 8.
Give me once.
I am giving it. Okay. আমি দিচ্ছি।
ওইদিকে রয়েছে। ছোট বইটাই দেখি। এইগুলোকে একটু পরিষ্কার করবেন, বইতে হাত দেওয়া।
I have marked.
Order 1 rule 8.
Right hand side rule 8. Because I am ventilating the grievances of all directors.
The court shall in each case where a permission rejection is given on a summary and the
It requires to be published, my lord.
It has to be published.
Yes, I will publish it, my lord. Notice is required to be published.
May apply to the court limit as a party, no part of the agreement or social be condemned.
One can join as respondent, one can join as petitioner.
Yes, that is all right. But then I was seeing whether any formal application is required to be filed.
Kindly take, my lord, one
permission, but then you have to seek for that permission. Can you seek that by way of a supplementary affidavit?
Yes, my lord, paragraph 7.
Affidavit, you bring things on record.
Kindly record my oral prayer, my lord, that in my humble, my lord.
It may cause problem in future. Only to crease out everything.
My lord, I'll cite judgment, my lord, if this is habitual practice, my lord, in this court also. My lord, we can pray, my lord, orally. This is not like that, my lord, under order 2 rule 2. This is not like that. This is the representative. Unless the court grants me permission, my lord, I cannot move. When I am highlighting an issues, my lord, which is affecting all, many persons, my lord, that leave is, this is a general leave granted. You also record my lord prayer.
কি বললাম? Leave has been sought for moving the writ petition under representative capacity under Order 1, Rule 8A. Now, Rule 8 within bracket 1. 1A.
Lordship,
Small a.
on humble prayer, since it's a very technical plea, I might be debarred because Order 1 representative capacity can also be challenged. So
Yes, yes.
They can grants them leave at this stage, then it will be difficult for me because I have to take instructions on that.
All right, very well. He has prayed. I am recording that. You take instructions and I am placing it a fortnight hence.
Because it's a very technical.
He'll also come up with proper instructions.
Much obliged.
Only thing, my lord,
it is only for the purpose of making things very clean that the application should be brought on record. Otherwise, had it not been so contentious, orally I could have. Let an application, formal application come on record, the necessary orders can be filed. The said prayer of the petitioner has been opposed by the learned advocate representing the state respondents. Stop. The petitioner is now it will be open for the petitioner to file a formal application seeking leave under Order 1, Rule 8(1) within bracket small a. Stop. Paragraph. Fortnight, I am posting it.
As the only thing, my lord, because I am facing problem, there are others facing problem. As soon as, my lord, from tomorrow onwards, we will be, my lord,
all right, let me see.
Some protection.
All right.
At least.
The matter is posted on 2nd April 2025. Learned advocate for the state respondents shall.
In April, I have some personal difficulty. Your lordship might take it on 3rd or 4th April.
3rd.
Humble request to you.
3rd.
4th April.
4th is a Friday. 3rd, I'll keep it. 3rd. 3 tarikhe kore din. Learned advocate for the state respondent shall produce written instruction in response to the complaint lodged by the petitioner annexed at page 91 of the writ petition. Stop. Paragraph. As the petitioner contends that she has been practically restrained from performing her work, which is infringing her right to life and livelihood and her right to carry on business, trade. Accordingly, the respondent number 5 is directed not to obstruct the petitioner in her usual course of business.
I'm grateful, mother. Extremely grateful for you.
Take your book.
Yes, well, I'm from the petitioner. My lord, in this matter, my lord, the writ petitioner is a victim of blasting in the minings. His
victim of
mining, my lord. Blasting for mining. His house is situated within the vicinity of the mines, my lord. And my lord, we make repeated
for my he has probably respondent number 3, West Bengal Power Development Corporation is the main answering respondent. He is seeking compensation or alternative accommodation for the damages.
Immediate stoppage of.
You are not representing.
Only the state.
All right. Show me the service upon 3-4. PDCL is
One of the private respondents have refused to accept the service, my lord.
private respondents means
The company.
5. 4-5.
The company, my lord, the
Tara coal mines. But WP PDCL?
My lord, I have served through the state, my lord, government period, my lord. So he says I can serve today itself.
Through the government period,
In
probably
the part of the West Bengal, my lord, that's why I did not
No, no.
serve separately.
They have a separate panel.
Please come.
In another difficult reason, my lord, after filing of this writ petition, my lord, they started blasting each and every day, and the agency of the Union of India, may I permit to file the
Agency of the Union of India.
India has not been made a party, my lord. But need to made a party, my lord, if your lordship kinds enough to give me leave.
The
My
ultimate
lord,
licensing
agency-
authority.
my lord,
Directorate of Mines.
Yes, sir. No. I have not made a Union of India party, my lord.
Directorate of Mines is a party.
Yes, sir.
And did you serve the directorate?
Yes, my lord. And my lord, after filing of this writ petition, the I have made a supplementary affidavit. The authority, my lord, give a communication that there is a violation in blasting, my lord. So
Authority means which authority?
Central government authority. My lord, I have not made party to that agency, my lord. I may be given leave so that I can add that agency a party.
Ministry of Labor
Yes, ma'am. Mines.
and Employment. Directorate of Mines Safety. Inquiries in summary already been conducted and violations observed during the address to the management. Acha. None represents the respondent numbers 2 to 6. No, 2 to 5. Affidavit of service is taken on record. Let notice be served upon the non-appearing respondents. Released on next Thursday, 27th.
Can you give me protection?
Who has refused?
The Tarakol Mines, the agency.
Achha.
After filing of the
Leave is granted to the advocate on record of the petitioner to implead the Union of India and its department, concerned department as party respondent in the instant writ petition and serve a copy of the writ petition upon the added respondent. Stop. The affidavit of service. Now, the unserved envelope of the unserved envelope sought to be served upon the respondent number 5 is retained with the record, but the writ petition is returned to the advocate of the petitioner. Take back the writ petition, the envelope will remain.
Can you give me some protection, my lord?
What type of protection?
Can you see the
I can see the crack.
After filing the writ petition, they are working like a work-like situation already each and every day, apprehending that there will be a
But
preventive
who
order.
will be the authority to look into it?
Respondent number 3, my lord.
Respondent number 3 you did not serve.
I can have only for blasting, my lord. Only for to regard to blasting, not for other works, my lord.
Learned advocate for the petitioner submits that after filing of the writ petition, the blast in the mines has increased manifold, for which the building of the petitioner has developed several cracks.
Structural cracks, my lord.
Stop. The said cracks are increasing day by day, and the structural stability of the structure is at stake. Stop. The life of the petitioner is endangered. Stop. Paragraph. In view of such submission, comma, the respondent number 3 and 4 are directed to ensure that no illegal blasts are carried out at the subject mine, and the structure of the petitioner is not damaged further. Next Thursday, let us see.
Only one line, my lord, has indicated that these respondents do not appear, but state appears.
Yes, the state is represented,
Well,
and your appearance will also be recorded.
that line.
That goes on to show that you were present.
But it may be construed that since he has served upon all.
No, your appearance is there.
I appear for the petitioner in this matter.
Yes.
Everyone has been served. Acknowledgement has come about the service. A notice given by the financer is a subject matter of challenge before your lordship. Lordship will straightway come to page 32 of the petition. 13.2 notice was given. We have given a reply to the 13.2. Thereafter, my lord,
Swatantra Micro Housing Finance Corporation Limited.
Bombay-based company, we have served it, delivered.
I am for respondent number 3 and 4, my lord.
How is the writ petition maintainable against this private entity?
They are the 13.2, they are coming within the fourfold of the Securitization Act.
Go before the tribunal. Why in the writ court?
And this 13.2 has been abused. It is a case of clear abusing the 13.2 proceeding, and the Securitization Act acted 13 without going 13.4, forcibly taking possession of the property of the petitioner.
Go before the tribunal. Sorry.
The conduct of the party.
No, nothing doing.
Police in action is also there.
Police in action, go before the police bench.
Kindly look at the notice itself. On the face of it, it is bad in law.
It cannot be done.
Kindly come to notice itself, my lord.
No, nothing doing.
Page 32. For once, lordship will private persons, my lord, property is at stake because of the high-handed act of these private financing companies, my lord, roaming around the city, my lord, and taking the.
And you are taking finance from them. At that point of time, it doesn't come to your mind.
Repaid the money. And after repayment of the money, we have given a reply to 13.2. 13.2 reply was taken care of. They have given a counter reply to 13.2. Then the steps have to be taken under 13.4. Without taking that step, a notice of taking possession forcibly has been given. Are we staying in a lawless land? Kindly come read for once page 32. Is it permissible under law? Yeah, they are saying that 13.2 was given by them.
The petitioner is aggrieved by steps taken by
give some protection to me, Malad, so that I can
finance company.
Take appropriate.
Namta dekhen to Swatantra Micro Housing Finance Corporation Limited. In taking steps for recovery of the loan amount under the provisions of the SARFAESI Act. Stop paragraph. The finance company being a private entity, writ petition against the same will not be maintainable. Stop.
Or my fundamental right is
it will be open for the petitioner to approach the competent forum for relief in accordance with law if so advised.
If that is so, Malad, if I am thrown out of position, Malad, at least give some protection to me.
If you are thrown out of possession, tribunal has enough power to put you back in possession.
My family, my wife, my daughter, they are staying, Malad. They will be thrown out without 13.4. That threat itself, Malad, what's the interference in a writ proceeding?
5.
Right to life, Malad. Right to life and liberty. Lordship can look at page 23 for once. Here it has been said that you are thrown out of position. If you don't vacate, I shall take over position physically. How can they say so, Malad? At least that protection be given for 15 days, Malad, so that I can go to the tribunal and take a protection there.
Yes.
My lord,
Still I make a prayer to your lordship.
My lord, in this matter, I am.
The Supreme Court is coming down very heavily upon courts who are taking steps in these surfacey matters.
These are not the proceeding under SURFACE. They are taking the law in their own hand. They have made a law on their own. And SURFACE
Yes.
name has already been lent therein.
Nothing
The
doing. Sorry.
protection of life, my lord. And
Sorry, sir.
this
Please.
remains state for 15 days. Only 15
Nothing.
days, I pray you, lord.
Yes.
In this matter, I am for the respondent, my lord. I have
Which
raised a very
respondent?
preliminary question, my lord.
Time never. Time never.
Which respondent?
I am for the bank, the respondent bank in this matter, my lord. Item number 5, my lord.
Yes.
I have raised a very preliminary question with regard to the territorial jurisdiction.
All right.
So I would beseech my lord, kindly hear me on this score before my lord comes to
Goes
the
into the minutes.
my lord. My lord, what the case they have made out, my lord? Kindly see their petition. First of all, I would like to point out one aspect of this, my lord. Kindly see the pleadings in the petitions. Normally, my lord, in the petition, there is a normal, innocuous or omnibus prayer or averment that these application, the records
of
of this,
action
records of this
are
application
within the appellate side jurisdiction
original
of
side
this court.
jurisdiction or outside the original. There is no such pleading to that effect. No such pleading. Why this matter should be
Moved before the Calcutta High Court.
Calcutta High Court. Kindly sees what they have impugned. They have impugned. They have purported to impugn the notices, the so-called notice, and the final so-called notice was issued by whom? My lord, kindly sees that page 200. The so-called notice was issued by Bank of India, Zonal Office, Star House, second floor, Joydev Bihar, Noyapatti, Bhubaneswar, Orissa. At page 200. Now they may say that the notice was issued also in the registered office of the company, which is in Salt Lake City. That they may say, but there is no averment to that effect in the entire writ petition.
No, but the record shows you have
I'm
served
coming to that. I'm coming to that. I have some judgments to satisfy my lord on this score away. My lord, thereafter, my lord, kindly sees their reply, my lord. They have a registered office, no doubt, in Calcutta. Their reply 205 corporate office at Kotok Road, Bhubaneswar. And my lord, thereafter, the ultimate order which they are challenging, my lord, at page 211, that is also issued from the office of the Bhubaneswar, Orissa. The loan in question was taken in Bhubaneswar, Orissa. All the loan transactions in question are in the state of Orissa. Now, my lord, I list this. My lord, this article 226 has been amended. Article 226(2) has been inserted in the year 1963 by incorporating the territorial jurisdiction, which means that writ petition can be entertained by the Honorable High Court having territorial jurisdiction, even if a part of cause of action has arisen there. My lord, here in this case, my lord, I am placing this case of Alchemist, my lord. Kindly see. My lord, আমি একটু সাইটেশনটা বলে দিচ্ছি 2007 volume 11 2007 volume 11 ও তো মুখস্থ SCC 335. My lord, kindly sees here in this case, my lord, kindly turns to page 340, my lord, paragraph 10. In this case, the respondents in this connection relied upon the following facts. Registered office and corporate office of the first respondent bank is at Gangtok. Secretariat of the second respondent state is situated at Gangtok, that is Sikkim. Offers were called from various parties at Gangtok. All offers were scrutinized and a decision to accept offer of the appellant company was taken by the first respondent bank at Gangtok. The state government decision not to approve the proposal of the appellant's bank was taken at Gangtok. The meeting of the board of directors, first respondent bank was convened at Gangtok and a resolution was passed to withdraw the later dated. Communication was dispatched by the first respondent bank to the appellant bank, Gangtok. The respondent therefore submitted that the High Court was wholly
right in dismissing the petition on the ground of want of territorial jurisdiction and the need no interference by this court. Before entering into the controversy in the present appeal, let the legal position be examined. Article 226, as it ordinarily enacted, had twofold limitations on the jurisdiction of High Court with regard to the territorial jurisdiction. Firstly, the power could be exercised by the High Court throughout the territories in relation to which it exercises jurisdiction. That is, the writs issued by the court cannot run beyond the territories subject to its jurisdiction. Secondly, the person or authority to whom the High Court is empowered to issue such writs must be within those territories, which clearly implied that there must be amenable to its jurisdiction either by residence or local location within those territories. No, my lord, I'm not troubling by reading the entire of it. My lord, kindly see paragraph 32, where in a different case was discussed. The judgment of the High Court was sought to be supported integral on the ground. A was carrying on business at Ahmedabad. Orders were placed from and executed at Ahmedabad. Documents were sent and payments was made at Ahmedabad. Credit of duty was claimed for export handled from Ahmedabad. Denial of benefit adversely affected the petitioner at Ahmedabad. A had furnished bank guarantee and executed bond at Ahmedabad. Now, my lord, upon considering all these aspects, my lord, I'm just going to paragraph 38, my lord. In the present case, paragraph 38, my lord. In the present case, the facts which have been pleaded by the appellant company in our judgment cannot be said to be essential ingredient or material fact as to constitute a part of cause of action within the meaning of Article 226(2) of the Constitution. The High Court, in your opinion, therefore, was not wrong in dismissing the petition. This was based on this. Alchemist was based on this decision of ONGC versus Utpal Kumar Basu. I am placing this matter. Right. Well, kindly see paragraph 8. Because on the basis of this alchemist was passed, my lord. Well, before reading paragraph 8, my lord. No, my lord. Paragraph 8, my lord. At page, my lord. 719. From the facts pleaded in the writ petition, that was pleaded in the writ petition. In this case, it was better, my lord. It was pleaded in the writ petition. It is clear that NICCO invoked the jurisdiction of Calcutta High Court on the plea that a part of the cause of action had arisen within its territorial jurisdiction. According to NICCO, it became aware of the contract proposed to be given by ONGC regarding the advertisement which appeared in the Times of India at Calcutta. In response thereto, it submitted its bid or tender from its Calcutta office and revised the rates subsequently. When it learned that it was considered ineligible, it was sent representation, including fax messages, to EICL ONGC committee, finally rejected the offer of NICCO and awarded the contract to some CIMM-CO at New Delhi on 27th January 1993. Therefore, broadly speaking, NICCO claims that a part of cause of action arose within the jurisdiction of Calcutta. It submitted its bid or tender from Calcutta and made representations demanding justice from Calcutta on learning about the rejection of its offer. The advertisement itself mentioned that the tender should be submitted to EICL at New Delhi. that those would be scrutinized at New Delhi and finally a final decision whether or not to award the contract to the tenderer would be taken at New Delhi. Of course, the execution of the contract work was to be carried out at Hazira in Gujarat. Therefore, merely because it read the advertisement in Calcutta and submitted the offer from Calcutta and made representation from the Calcutta would not, in our opinion, constitute facts forming an integral part of the cause of action. So the cause of action may arise, but that should be an integral. But here also so many things happened in Calcutta, and that was even pleaded in the writ petition. Still, the Honorable Supreme Court held no cause of action is arising in Calcutta, and therefore, so also the mere fact that it sent messages from Calcutta and received a reply thereto at Calcutta would not constitute an integral part of the cause of action. Besides, the facts measures cannot be constituted as convict rejection of the offer and such and such. We are therefore of the opinion that even if the averment in the writ petition is taken as true, it cannot be said that a part of cause of action arose within the jurisdiction of Calcutta High Court. এটা হচ্ছে না সোয়াইকান ওএনজিসি ভার্সেস উৎপল কুমার বাসু। Now, my lord, may I be permitted to place my lord. The state of Rajasthan versus Swaika Properties. Well, can you see paragraph 7 and 8? Rather, I am placing paragraph 8, page 223, my lord. My lord has.
Yes.
The expression cause of action is thusly defined in Mulla's Code of Civil Procedure. The cause of action means every fact which, if traversed, it would be necessary for the plaintiff to prove in order to support his right to a judgment of the court. In other words, it is a bundle of facts which, taken with the law applicable to them, gives the plaintiff a right to relief against the defendant. The mere service of notice under section 52 of an act on the respondent at their registered office at Brabon Road, Calcutta, within the territorial jurisdiction of West Bengal, state of West Bengal, could not give rise to cause of action within the territory unless the service of the notice was an integral part of here. The service was notice happened. Not only that, this company was having a registered office in Calcutta in Brabon Road, in the state of West Bengal. Thereafter, also service of notice happened, but still, the Honorable Supreme Court said the entire cause of action culminated in the acquisition of land under section 52(1) of the Act arose within the state of Rajasthan, that is within the territorial jurisdiction of Rajasthan High Court, at the Jaipur bench. Oh. The answer to the question whether service of notice is an integral part of cause of action in the meaning of Article 226(2) of the Constitution must depend upon the nature of the impugned order giving rise to a cause of action. The notification dated February 8, 1984, issued by the state government under section 52 of the Act became effective the moment it was published in the official gazette, as thereupon the notified land became vested in the state government free from all encumbrances. It was not necessary for the respondents to plead the service of notice on them by the special officer, town planning department, Jaipur, under section 52 of the grant of an appropriate writ, direction or order under Article 226 for quashing the notification issued by the state government under section 52(1) of the Act. If the respondent felt aggrieved by the acquisition of their lands situated at Jaipur and wanted to challenge the validity of the notification issued by the state government of Rajasthan under section 52(1) of the Act, By a petition under 226, the remedy of the respondent for grant of such relief had to be sought by filing a petition before the Rajasthan High Court bench, where the cause of action wholly or in part arose. My lord, kindly see the head note also. I'm referring to the head note also, page 218 of this matter, my lord. I'm reading from the middle, my lord. Held, my lord, that held. First paragraph, second paragraph, third paragraph. The cause of action neither wholly nor in part arose within the territorial limits of Calcutta High Court. Mere service of notice under section 52 of the Act on the respondent at their registered office within the territorial limits of the state of West Bengal could not give rise to a cause of action within territorial unless the service of notice was an integral part of the cause of action. Here, my lord, in this case, my lord, this case was, according to me, was in a better footing. In the case in hand, in the instant case, my lord, there is no such pleading or there is no such averment or no such case made out that yes, we have received our notice in Calcutta in our registered office. Even had it been so, that would not have given them the right to approach before this Honorable High Court by filing a writ petition before this Honorable High Court. That is not an integral part of the cause of action. And here only they are saying, not only saying, there is no pleading. This has come up from the bar since we are having our registered office in Calcutta. So whatever the transaction took place in the state of Orissa, we are entitled to file a writ petition here before the Honorable High Court at Calcutta. So, my lord, the place or the having the registered office cannot be a criteria, cannot be a incident of jurisdiction, my lord. Cannot be a criteria to have jurisdiction before this Honorable High Court, my lord, for filing an application on Article 226, my lord. My lord, this was extensively considered. All these judgments were extensively considered by our Honorable High Court, by a coordinated bench, my lord. And
yesterday you handed over a copy.
I'm just yesterday it was a net copy, my lord. It is
all right. It is the same thing.
But here also, my lord, they are having the registered office in this case, my lord. They are having the registered office in Calcutta, but all the alleged incidents, transactions took place outside the territory of Calcutta. So this Honorable High Court also held that cannot give you
very well
any jurisdiction.
Let him reply. Yes, the petitioner, territorial jurisdiction.
No, this is a proposition with which one cannot have a quarrel with. That a cause of action has to accrue within for me to invoke 226(2). But what is a cause of action and what forms an integral part of the cause of action is the issue. And it is also, I'll rely on the judgment cited by my learned friend, that if any part of the cause of action accrues within the jurisdiction of this Honorable Court, 226(2) is to be invoked, primarily because of the language of the 226(2) itself, that mere situs of where the authority is situated is irrelevant. So I will just have to show that a part of the cause of action is accrued. Instead of relying on what I'm saying, if your lordship looks at the alchemist judgment, it's a very oft-cited judgment. Kindly have a look at paragraph 37, the concluding portion of the judgment.
From the documents annexed to the writ petition,
I will
show that something arose within.
Everything has happened within. If I may just show paragraph 37 once to at least give the conspectus in which I'm showing your lordship the fact.
Yes.
Paragraph 37 of the alchemist judgment, 2007-11 SCC. From the aforesaid decisions, and keeping in view the ratio laid down in a catena of decisions by this court, it is clear that for the purpose of deciding whether facts averred by the appellant petitioner would or would not constitute a part of cause of action, one has to consider whether such fact constitutes a material, essential, or integral part of the cause of action. It is no doubt true that even if a small fraction of the cause of action arises within the jurisdiction of this court, the court would have territorial jurisdiction to entertain the suit petition. Nevertheless, it must be a part of cause of action, nothing less than that. So this, and in none of these judgments, with deepest of respect to these decisions, what is an integral part, what is a part of cause of action has really been explained. Everyone follows that. All judgments, Your Lordship will see the cause of action is a bundle of facts, and they just do that and let it be. Now, just to highlight what could be for Your Lordship's kind consideration, kindly have a decision that we found yesterday, which really identifies what would be an integral or a part of cause of action, what may constitute. This is a judgment of our court, Vinod. Kindly have a look at paragraph 48. I'm relying on paragraph 37 of the judgment that my learned friend has cited, and paragraph 48 just to highlight what would be a part of a cause of action. To hold that service of an order or a notice on the addressee would never give rise to a cause of action to move the court within whose territorial limits the order or notice is received may not be reasonably sound. If a service of an order or a notice is an event of substance, that is an event which is a material, essential, or an integral part of the list connected with the action that is impugned in a writ petition, there is no plausible reason as to why the same should not be construed as constituting a material, essential, or integral part of the cause of action. The plea of affectation of right or interest by reason of such order or notice being served, if based on a substantial fact forming part of the bundle of facts constituting the cause of action, would indeed be relevant for determination of the question as to whether the writ petition ought to be entertained or not. Hence, the decision to withdraw the award and pluck from the petitioner was never communicated to him prior to the public notice being published in the print media, and it is such publication, the only one in the series to make the public aware of the penalty imposed on the petitioner, that vitally affects the reputation and respect that he has earned over the years. Such affectation having taken place in Shantiniketan, where the petitioner alleges he read the public notice for the first time and derived knowledge of the impugned decision of so-and-so, it is an integral, essential, and material part of the list constituting the cause of action to approach this court and conferring jurisdiction on this court to entertain the writ petition. Now, Your Lordship will just have a look at my praise. In none of these decisions, kindly have a look at these my prayers, that Your Lordship will find at page 44. A writ upon the nature of mandamus commanding upon the respondents quashing of the order dated 15 February 2025. This is at page 211. This was received as a matter of record by me within jurisdiction. Next, show cause notice 27 December 2024. This is at page 200 of the application. This is received by me within. Declaration that all steps taken on the basis of the impugned order dated 15 February and accordingly liable to be set aside. Declaration that have not been provided natural justice. Declaration that the order is contrary to the RBI circular, and prohibition. Well, not just any part of the cause of action. The entire cause of action has accrued within. This is not a case where a tender has been floated in Bhubaneswar. I have participated in the tender in Bhubaneswar. The tender has been rejected in Bhubaneswar. I have received communication of the tender rejection in Bhubaneswar, and here I have challenged the rejection. This is a case where I've been declared, my account has been declared as a fraud. That account is an account here. The show cause notices have been received within. The impugned order has been.
The account here.
My bank account is here. The loan has been granted from there. My instruction on my bank account is here. The statutory auditor's report is received within.
And the auditor is here from here only.
And from here. And based on his report, all of them purportedly find my account to be a fraud.
And your bank account is, where is your bank account? Which bank? This
Well,
is the bank of?
My instructions are there. Within. And my lord, one more fact I'll indicate. Your lordship may take judicial notice of it, that all these banks and most of them have proceeded against me in NCLT Kolkata under section 7 of the IBC. All these proceedings have been taken out by them within. My lord, knowing your lordship's view, it's a desperate legal attempt to say that this court does not have the jurisdiction. My lord, if I may look at it this way, if your lordship was sitting in the original side jurisdiction and I was filing a suit, I would be definitely, as a matter of course, entitled to clause 12 leave. Bank account taken.
Where is the bank account? Show me something.
No, the documents would be there. Kindly give me 1 minute, no? That everybody knows. Tell me, you were telling me about the account, tell me. That I know that the loan was obtained here because we filed suits in respect of the guarantees and the loan here. Here, unfortunately, from their documents, I'll not be able to show. At least it doesn't highlight bank account to be within.
The address of the bank is there of Orissa.
Yes, the address. Well, your lordship will also find that the statutory auditor is within.
Yes, that I have seen.
The registered, well, this is not a case where I've invoked 226(2) just because my registered office is here. This is a case where I've been declared as a fraud and I've received it within. My show cause notice is within. The statutory auditor's report is from within. Every part of cause of action has accrued here. Only the respondent citus is elsewhere. And this fact has come to be considered in a division bench judgment of our honorable court. If I may just also formally place that, where a delisting order passed outside was challenged in this honorable court. The delisting took place here, and the court held that this is an important part of the cause of action. I have to copy down. কতক্ষণ তুমি দেখো অ্যাকাউন্টটা কোথায় আছে অ্যাকাউন্ট এখানে আছে আমি দেখেছি তুমি দেখো এটা paragraph 2 your lordship will just have a look at once. Just that appellant number 1 is an approved listed vendor of Indian Railways. Lord, kindly disregards everything else. None. Fact. Here your lordship will find that I was delisted, paragraph 7. Being aggrieved by such temporary delisting, the writ petitioners filed so-and-so for issuance of writ of mandamus to set aside the impugned order not to give effect. Then this got dismissed. Honorable single bench, after hearing the learned counsel for both sides and after taking into consideration the citations referred by both parties, has been pleased to inter alia hold that the writ petition number 1 has only received the impugned order as a registered office, while supply of equipment was made by writ petitioners to RDSO Lucknow. The contract was entered into at parties at Lucknow, and payment towards such supply made by the petitioner was at Lucknow. Writ petitioners impleaded other respondents having their office at Kolkata and who have nothing to do with the impugned letter of temporary delisting of the writ petition, only for the purpose of invoking the jurisdiction of this court. Pleased to hold, paragraph 9, the mere fact that the writ petitioner has registered office or it has obtained finance from banks in Kolkata and by impleading other authorities of Indian Railways having office in Kolkata would not ipso facto confer jurisdiction to courts in Kolkata when substantial, integral and principal part of cause of action accrued at Lucknow. Only issue that requires determination is appeal is whether the longer then something else. My lordship will just turn over, my lord, because this is kindly have a look at paragraph 17. Having considered the submissions made by the respective learned counsel and on having gone through decisions referred by them in support of the respective contentions, it appears whether or not cause of action wholly or in part by filing a writ petition has arisen within the territorial limit of a particular high court ought to be decided in the light of the facts of the case qua the nature and the character of proceedings under Article 226 of the Constitution. That is, within the limits of the High Court, in a writ application has been filed, any of the facts which would entitle the petitioner to obtain relief under Article 226 of the Constitution have arisen. In other words, in order to maintain the writ application, the petitioner has to establish that within the territorial limit of the court's jurisdiction, prima facie a legal right claimed by him has either been infringed or is threatened by the respondent, and such infringement may take place by causing him actual prejudice or loss of his legal rights. Accordingly, when the impugned act of the respondent takes effect within the territorial jurisdiction of a particular high court, it may entertain the writ petition of the person aggrieved, notwithstanding the respondents have offices or residences outside the territorial jurisdiction. Therefore, whether this court has territorial jurisdiction to entertain the writ petition or not has to be decided keeping in view the provision of Article 226(2) of the Constitution. Paragraph 21, 19 is again a reiteration of Alchemist. In view of Article 226(2), if a part or a fraction of a cause of action arises within the territorial jurisdiction of a high court, the concerned high court will have the jurisdiction over the writ petition irrespective of the fact that the respondents reside outside. (24) kindly have a look at the prayer is set out. Similar to my prayer D prohibition, here a writ of in the nature of mandamus do issue commanding respondents not to take any step or further step against NIT so and so, including opening of tender so long as the petition number 1 remains temporarily delisted. From 27, paragraph 27. From the above discussed facts, it cannot be concluded with certainty that the integral part of the cause of action of the writ petition has exclusively arisen in RDSO Lucknow, just because the impugned order dated 17th August was issued by the respondent number 4. Malad, if I may just pause here for a moment. The bank will have to then indicate to your lordship that everything has accrued there only because the order has been issued from there. And in no other part has any part of cause of action accrued. Simpliciter because of the situs of the authority which has issued the order. Well, such an argument would be absolutely in the teeth of the language of Article 226(2). Which is why in Alchemist paragraph 37, Supreme Court makes that distinction that even if a fraction of a cause of action is accrued, now your lordship has this arduous task of ascertaining if a fraction of the cause of action is accrued or not. Now, what would be a fraction of a cause of action, which is why I was relying on Justice Doctor's order and this order. Well, if the order of here your lordship would find that the order of delisting takes effect here. Paragraph 36. Since the impugned order of temporary delisting affecting the appellant number 1 would be effective only upon communication, and therefore it takes effect here. Well, it can't be anybody's case that just by issuing it and keeping it there, could have been declared as a fraud. All notices to appear are here. Show cause notice here. Order received within. And your lordship has seen the master guidelines, RBI circular, that unless this is informed to me, I can't be declared as a fraud account. So it's only on receipt that my cause of action to sue accrues, or only on my receipt does his cause of action to declare me as a fraud account accrue. This is very different from all these judgments which have been cited. Thing tender is there. I participated from here. Well, all that takes effect there. And rejection of tender does not take effect on receipt of rejection of notice.
And on merits, what is your submission?
I'll just, on merits, I'll just indicate. It will identical to the other two matters that your lordship has found. The one that show cause notice looks detailed, but none of the documents that were there have been given. If your lordship looks at the...
Then I ask for a reply, they don't reply to my reply, direct decline.
If your lordship looks at the show cause notice, it is at page 200. It refers to a host of events, but not one document that they sought to rely on has been disclosed. 14th of January 2025, I respond, which is at page 205. And then the order directly. They've not even dealt with my reply.
Has any of the orders been put up in the server?
No, Milan.
Not a single one.
We were also looking for that. Then it would have. Huh? No. If your lordship keeps it tomorrow or day after, we'll be able to. I understand. So for committee also, I will be able to rely on it. As a judicial precedent on principle of committee, it might save your lordship the trouble also, because it's going to be verbatim that. If your lordship considers staying this for 2 days and allows us to come back, or your lordship can reserve this for judgment and...
No, I have already reserved a lot for judgment.
I can come back.
I won't reserve anything now.
But we've troubled your lordship enough with these matters. It might be convenient to your lordship if those orders are there.
Yes. Tuesday's order has not been served.
No.
One has been.
Only the forensic audit to reserve.
Only that one where Mr. Thakkar had appeared to serve and come back, and on that day.
No.
Check once.
হ্যাঁ কোর্টে টাইম বেশ হবে, তুমি তো আজ সকালবেলা চেক করেছো। হ্যাঁ একবার চেক করো না।
Anything in reply with regard to the territorial jurisdiction?
কতক্ষণ চেক করো না, জাস্ট তোমাকে টাইম থেকে একটু দেবে যাবে। কোনটা চাও? কোনটা চাও? ও বলছো না তো কোনটা চাও, কোনটা চাও? এটা আর এটা দাও। ওই এটা মানে সবকটা নিয়ে নাও, মানে কি করছো তুমি?
My lord, he has not made out any case that his submission is making out from the bar, my lord. That why at the outset I submitted, my lord.
That awardment is not there.
There is no omnibus awardment that all
cause of action arose
within the. So, my lord, kindly sees even these judgments, my lord, this alchemist judgments, my lord, kindly sees the head note, my lord. It is very clear, my lord. I'm reading the head note only, the middle portion. In the
present don't go by head notes. Go into the body of the order.
Well, here also the case was that.
Which one?
In alchemist, my lord. Case was that negotiations, appellants had his registered office in place called C.
Correct.
Negotiations took place in C. Performance of contract was in place C. Letters of acceptance of proposal and rejection therefore are received at C.
Why did the bank move the NCLT here in Kolkata?
Well, that would not, I do not have that instructions, my lord. I do not have that. But, my lord, I respectfully submit in this respect, my lord, even if the bank had moved, whether they have taken the point of territorial jurisdiction or not, I do not know.
No, because they admit that the cause of action arose within Calcutta.
Not confer the jurisdiction.
Yes, by consent it cannot be conferred. That is true. But then this issue has not been raised out by any of the parties.
Before which has moved in NCLT, whether there is any cause of action here in Calcutta or not, What is the matter? What is the substance in this
Same
matter?
thing.
No, may not be. We do not know. I do not know.
No, even if he
The
doesn't know,
materials,
the order
the
is.
materials involved in this matter, whether are same or not, I do not know.
It
But I
has
am-
to be the same. How can it be different?
I am declared as
Maybe
a
there-
fraud
maybe
here.
Maybe there are certain aspects or certain elements in this matter which are concerning this Calcutta. We do not know.
Listen, you cannot say that two courts doesn't have similar jurisdiction. It can be.
No, Manoj, but it
Orissa
is
may
my-
have,
Manoj,
but
may I-
here also.
Forgive
They
my
have filed
interjection.
a suit
But
challenge.
I must indicate that under the IBC, they will have to come where the registered office of the corporate debtor is situated.
Yes.
So that
That
could
is
have,
the reason
that is the reason why they've come
why
there.
they have
So-
come.
But my case is slightly different. In addition to that, it's where the order takes effect. I'm declared as a fraud here. My show cause notice is written here, and all orders of challenge, all notices of challenge have all been received within. This is not a case, Manoj, where I participate in a tender rejection.
followed it.
My lord, this is the case, my lord, where the alchemist has clearly said that the having registered office.
No, alchemist.
No, but then at the same time, not
I'm-
only having
No,
cause of
only
action
not only that,
also.
my lord, kindly, I also appreciate the fact that they have challenged the order of the auditor by filing a suit before the Bhubaneswar. So they themselves have availed that forum, have approached the territorial jurisdiction before the Bhubaneswar.
But can you say that the Calcutta High Court doesn't have
My
any
lord, they have not been able to show any, beside having an office and receiving the document or
No.
making representation.
all their documents are also over here.
No, that
The
is their
forum convenience is also to be taken into consideration.
My lord, all decisions and all the accounts, loan has been sanctioned from Bhubaneswar. That is the admission. Loan has been sanctioned from Bhubaneswar. This loan is ultimately, this loan has become fraud. After getting this loan, it will become fraud, and fraud declaration has been from Bhubaneswar. So cause notice was issued from Bhubaneswar, and all the transaction of this loan took place in Bhubaneswar. That is admitted, my lord. They have, beside, their only claim is that they are having a registered office in Calcutta and they have received the so cause notice in Calcutta.
Received, you have served.
We have served the so cause notice in Calcutta, not only in Calcutta, also in Bhubaneswar, but also
Because they have a corporate office over there.
we have served in Calcutta, and not only that, they have issued their so cause notice from here, from Calcutta. So that is the case they have made out. Only beside this, they do not have anything to say that why this Honorable High Court would have a jurisdiction over this matter. My lord, kindly appreciate these decisions. They have time and against Waika Properties, Utpal Kumar Basu, Alchemist, which I have placed before my lord, even Kushu Magnot. I am not placing it right now. Kushu Magnots. And lastly, by considering all these decisions, the coordinate bench of our Honorable High Court also said that only because of these reasons, having an office, receiving the order of rejection, cannot give the jurisdiction, cannot confer the jurisdictions. It is not an integral part of the cause of action.
Very well. Please come, Pradeep.
With your
এই
lordship,
পাওয়া গেল
lordship's kindly.
yes কোনো কিছু একটাও নাই হ্যাঁ কিন্তু আমি কালকে ইয়ে করে দিয়েছি সই করে দিয়েছি ফাইল আসেনি The petitioners challenge the show cause notice and the declaration of fraud by the bank on the ground that the data and documents relying on which the show cause notice and the declaration was made were not served upon the petitioners. Stop. A preliminary objection has been raised by the learned advocate representing the bank with regard to the territorial jurisdiction of this court to entertain the writ petition. Stop. It has been submitted that the entire cause of action arose outside the jurisdiction of the Calcutta High Court. Stop. It is only that the show cause notice and the communication declaring the petitioner's account as fraud is within the Calcutta High Court jurisdiction, as the petitioner number 1 has its registered office within the jurisdiction of the Calcutta High Court. Stop. That apart, all the facts leading to the instant case arose outside the jurisdiction of this court. Stop. It has been submitted that no averment has been made in the writ petition with regard to the place where the cause of action arises. Stop. The bank contends that the petitioners ought not to be permitted to move the Calcutta High Court for relief. Stop. In support of such submission, reliance has been placed on the judgment delivered by the Honorable Supreme Court in the matter of Alchemist Limited and another versus State Bank of Sikkim and others, reported in 2007, 11 SCC 335. State of Rajasthan and others versus Messrs. Swaika Properties and another, reported in 1985, 3 SCC 217, Oil and Natural Gas Commission versus Utpal Kumar Basu and others, reported in 1994, 4 SCC 711, and the judgment delivered by a coordinate bench of this court on 13th December 2021 in WPA 12067 of 2021 with Can 1 of 2021. Kamsco Industries Private Limited and others, Banan, versus Union of India and others. In all the aforesaid decisions, the court consistently held that mere service of notice at the registered office could not give rise to a cause of action within that territory, unless the service of such notice was an integral part of the cause of action. For the purpose of deciding whether the facts averred would or would not constitute a part of cause of action, one has to consider whether such fact constitutes a material, essential, or integral part of the cause of action. It is no doubt true that even if a small fraction of the cause of action arises within the jurisdiction of the court, the court would have territorial jurisdiction to entertain the petition. The bank paragraph, the bank contends that in the instant case, the loan was obtained by the petitioner outside the jurisdiction of the court, the fraud was detected outside the jurisdiction of the court. And it is only because the petitioner number 1 has the registered office at Kolkata, the notices are served in Kolkata. Stop merely having the registered office in Kolkata will not give any right to the petitioners to invoke jurisdiction of the Calcutta High Court. Prayer has been made for dismissal of the writ petition on the ground of lack of territorial jurisdiction of this court to entertain the writ petition. Paragraph. In support of the submission that the Calcutta High Court has the jurisdiction to entertain the writ petition, it has been submitted that the entire cause of action to file the writ petition arose within the jurisdiction of this court. It is only that the situs of the office of the respondents is outside the jurisdiction of this court. Stop. The show cause notice, the order declaring the petitioner's account as fraud, the engagement of the forensic auditor, are all within the jurisdiction of this court. Stop. The records of the petitioner number 1 company are within the jurisdiction of this court. Stop. The bank invoked the jurisdiction of the National Company Law Tribunal at Kolkata because the registered office of the petitioner number 1 is in Kolkata. Stop. The right of the petitioner got affected because of the illegal because of the illegal and arbitrary manner of declaration of fraud within the jurisdiction of this court. Stop. All the aforesaid constitutes material and integral part of the cause of action for invoking the jurisdiction of this court. In support of the said submission, learned advocate for the petitioner relies on the judgment delivered by this court in the matter of এটা কপি করবেন তো আচ্ছা delivered by this court on 14th December 2021 in match number such and such, then the name of the parties, and the judgment delivered by this court on 7th delivered by this court in the matter of Pankaj Panwar versus Lalit Kala Academy, reported in AIR 2015 Cal 67, wherein the court held that the plea of affectation of right or interest by reason of the order / notice being served, if based on a substantial fact forming a part of the bundle of facts constituting the cause of action, would indeed be relevant for determination of the question as to whether the writ petition ought to be entertained or not. Step. If the affectation of right takes place within the jurisdiction of this court, the same has to be taken as an integral, essential and material part of the list constituting the cause of action to approach the court and approach the court. Stop. Paragraph. Upon hearing the parties and on perusal of the materials on record, it appears that because of the petitioner number 1 having its registered office within the jurisdiction of the Calcutta High Court, all notices and orders are served upon the petitioners within the jurisdiction of this court. Stop. The right of the petitioners to defend themselves gets affected within the jurisdiction of this court. Stop. The records of the case lies within the jurisdiction of this court. Stop. The forensic auditor conducted the forensic audit within the jurisdiction of this court. And as such, it cannot be denied that this court does not have any jurisdiction to decide the issue, or that it cannot be denied, it cannot be said that, or that no part of the cause of action arose within the jurisdiction of this court. Stop. On the contrary, it is seen that material, essential, and integral part of the cause of action arose within the jurisdiction of this court, thereby conferring jurisdiction on this court to decide the issue on merits. Stop. Accordingly, the preliminary objection raised by the bank to entertain the writ petition cannot be accepted. Stop. The matter has been heard on merits also. Stop. It appears that the subject bank happens to be one of the bank in a group bank in a consortium of banks which granted loan in favor of the petitioners. Stop. The lead bank, the Canara Bank engaged a forensic audit reporter, forensic auditor to conduct audit of the account of the petitioners, and the said audit report formed the basis for issuance of the show cause notice to the petitioner for declaration of fraud. Stop. Surprisingly, the documents and the data relying on which the show cause notice was issued were not forwarded to the petitioners. Stop. According to the bank, all details and documents were in the knowledge of the petitioners, and there was no requirement of further service of the documents and data all over again. Stop. Paragraph. It further appears that prior to declaration of fraud, opportunity of hearing was also not given to the petitioners on the ground that the same was not sought for. Stop. Paragraph. This court in blank, on blank, decided a similar issue and held that it is obligatory for the bank to forward all documents / data to the borrower for the borrower to give a meaningful response to the show cause notice issued. Stop. An opportunity of hearing is also required to be given to the borrower in line with the judgment delivered by the Honorable Supreme Court in the matter of blank. Next, in view of the above, the show cause notice and the steps taken in furtherance thereto appears to be contrary to the master directions on fraud published by the Reserve Bank of India. Stop. The same are liable to be set aside and are set aside. Stop. The bank, however, is granted liberty to take steps in the matter in accordance with law. Disposed.
Ladyship, affidavit of
Risk management.
Ladyship, affidavit of
Risk management on fraud, 2024. Affidavit of service is taken on record.
Item number 6. Well, item number 6, I read by Mr. Kolol Vasu, is only like I praying for my today's accommodation, my tomorrow.
Why don't you place it?
Well, he mentioned is because, but they are in courtroom number 26.
No, let him remain busy. You are the on record. You can proceed. He'll join.
Because my lord, there is I need one instruction because they have handed over one copy document that they have already my lord given a physical person to me. I am disputing about that. But that's why I need an instruction, my lord. If my lord possible, my lord, kindly.
What is the case made out? You
case, my lord, is that I am an auction purchaser. I purchased a property.
Two persons are there.
Yes, my lord. We are a highest bidder. We have purchased that property. After thereafter, my lord, they have given a symbolic possession. And thereafter, my lord, what happens? Series of cases.
Physical possession has not been given.
Yes, my lord. Despite of that, my lord, when I filed this writ application, suddenly, my lord, they have given a letter, my lord, that they have handed over a physical possession. But
to whom?
My lord, he addresses me because I have sent a legal notice to him. Handed over a physical person. There is a my lord on resolution. They have annexed that my client has put the signature. That's why I am taking. I want to take instruction, my lord.
Let me hear the bank. You are the bank.
They have handed over possession on
to whom?
To the petitioners. And to their satisfaction, they have stated in that letter, I am carrying that. I am handing over to my learned friend also. For the court, they say they are satisfied with the physical possession and they will not have any further claims in respect of possession in respect of the property. Now that letter was that undertaking was given in 2002 at the time of issuance of the sale certificate.
Given in date? Handover 26th of February 25?
My lord, there is no such seal. My lord, kindly see that.
1 minute. You filed a writ petition on the 26th of February.
Yes.
Handing over a physical possession to Dr. such and such and Dr. such and such. Informing that as per available, we are the property client.
It is their signature, they have stated.
Page 2 of the document that it handed over.
Yes.
At the bottom, it is written draft judgment dated 3/8/2022. What is it?
DRT judgment. They have lost my lord,
DRT
that
judgment.
case, and they have not handed over that judgment, my lord.
As is where is basis, is somebody else in the property?
Yes, my lord. There is also, my lord, I made a supplementary affidavit. My lord, there is another writ application I have filed. My lord, Justice Tithankar Ghosh gave an order. My lord, thereafter, my lord, bank has not given a physical person to me. When I filed this writ application, suddenly they have given a letter to me, addresses to me that we have handed over the physical person. They trying to shift their liability.
Why?
2022,
because my lord, they knew everything, my lord. My lord, we are the judgment debtor, my lord, civil suit, we got the order, but despite of that, my lord, they have not given the possession, my lord.
Who is in possession?
My lord, we have got a symbolic possession. The person
who is in physical possession?
My lord, physical possession is, my lord, one person, my lord.
Why have you?
SR oath.
Why have you not implemented that person as respondent?
Because my lord, these are my lord a claim against the bank because we have my lord already purchased that property from their.
That the court has followed, but somebody else is in possession according to you, and you want that person to be ousted.
Yes, my lord.
Through the bank.
Yes, my lord.
Through the bank, right? You will not make that person a party.
Yes, my lord. Can you give me liberty? Herein now, my lord, I shall add the party and my lord.
Please come.
They were not.
The petitioners are aggrieved. As the
My lord,
bank
supplementary affidavit, my lord.
failed to deliver physical possession of the auction property to them, despite being the highest bidder and despite handing over symbolic possession to them. Stop paragraph. Learned advocate for the petitioner submits that the subject property, now that a third party is in physical possession of the subject property. Stop. The said third party has not been implemented as party respondent in the instant writ petition. Stop. Any order passed in the instant writ petition will certainly affect the right of the said party. Stop. In view of the above, leave is granted to the advocate on record of the petitioner to implead the person who is in possession of the secured asset as party respondent in the instant writ petition and serve a copy of the writ petition upon the added respondent. Stop. What is the supplementary for?
Well, supplementary for my lord, after filing of this writ application, they have served a copy that they have handed over the physical person. That's my lord. Later, I have annexed and filed a
Alright.
supplementary affidavit. And
It
also
is the same letter, possibly?
I have to get a copy of the supplementary.
Same letter, my lord. Can you see this?
Yes,
Give a copy to him.
Yes, my lord. I shall. And order passed by the Honorable Justice Tirthankar Ghosh, my lord.
Achha. On the prayer of the learned advocate representing the petitioner, the supplementary affidavit filed by
My lord, handed over.
the petitioners is taken on record, and copy of the same handed over to the learned advocate representing the bank in court today. Stop. Next. Learned advocate representing the bank asserts that physical possession was delivered to the petitioners in February 2025, and the petitioners took over the physical possession upon putting their seal and putting their signature. Stop paragraph. Released the matter on 2nd April 2025. You can take this back because this is already on record.
And one more submission, Lordship had indicated the physical possession was handed over in 2025. It was handed over on 3rd August 2020.
3rd August?
Physical possession was handed over on 3rd August 2022.
2020? Two?
Yes, ma'am.
The document you relied
That was
upon is
that was
26th of February.
That is the communication letter, ma'am. That is not the actual date of handing over of the physical possession.
When you handed over physical possession, is there anything on record?
Yes, but kindly seize
There is a sales certificate, my
issue.
lord.
Well, it is mentioned there.
Sales certificate is something else.
Sales certificate, my lord. That is
on that date, it is indicated, my lord. On that date itself, the physical possession has been handed over. Your lordship, yes, my lord. Your lordship will kindly find out.
Lastly, Kunto, learned advocate, the bank is directed to file a report by way of affidavit disclosing the date of handing over of physical possession to the petitioners, along with supporting documents. Stop. Such report shall be prepared and circulated by 28th of March.
This may quite be a subsequent development because they might have lost possession after taking physical possession.
No.
Maybe.
Maybe.
You can come up with all your submissions.
Yes.
Because once you deliver possession and then somebody is thrown out and somebody
No,
enters,
there's no
you
liability.
can never,
Cannot
the
be-
bank will not have any liability.
Yes.
True.
Item number 7.
Item number 7, I am for the payment, my lord.
Yes.
After going through the, my lord, Justice Padiola's latest judgment, my lord, I passed in, my lord, 24th of January 2025, Supreme Court latest judgment
Regarding
SRPC
what?
application, my lord. I am just
SRPC.
placing, my lord, SRPC application.
Go before the
I
tribunal.
am just placing, my lord, page 31, paragraph number 6 once, my lord.
31, paragraph
Page
6.
38, paragraph number 6, my
8.
lord. I have it. The petitioner state the HDB financial service. I took a loan from that service, my lord. Thereafter, my lord, proceeding, I have started proceeding as SRPC Act proceeding started before the tribunal, my lord, on 2022, my lord. That proceeding is pending and date for fixed, my lord, for 17 of August of this 2025, my lord, for final argument of the matter, my lord. During that process, my lord, respondent number 7 came up with an application that respondent number 7, my lord, they took this application before the Chief Judicial Magistrate and filed this miscase, my lord, on the ground that they have a paragraph
So
number
you
7, my
first tell me, how is the writ petition maintainable against the respondent number 5? Please come. The petitioner challenges the action taken by the respondent number 5, HDB Financial Services, under the SRPC Act. Stop. The respondent number 5 being a private entity, writ petition against the said entity will not be maintainable. Stop. In view of the above,
my lord,
the
respondent number
petition-
7, I am challenging, my lord.
Respondent number 7.
Yes, my lord. I took a loan from the respondent number 5.
Yes.
I am
And
SRPC
7 and respondent number 5 is taking steps to recover the loan amount.
No, my lord.
What? No.
7, my lord.
Loan amount is of the respondent number 5. It has now gone to the asset reconstruction company, ARCIL. Acha.
In view of the above the instrument mentioned.
Is held to be not maintainable, and the same stands dismissed. It will be open for the petitioner to approach the competent forum for relief if so advised.
Grateful, my lord.
I can.
8 minute, may I please, your lordship? My lord. My lord, yes, last occasion, my lord, they have given a report, my lord, and from that report, I would like to seek the pleasure of your
But
lordship.
what is your case?
My lord, the case was that the certain name of certain outsiders were recorded.
All right.
In the
Record of rights.
in the record of rights. They came up with a report, my lord, and your lordship has been pleased to. It was the pleasure of your lordship to give me an opportunity to go through the report, my lord. I would draw your attention of your lordship, my lord, to only at the fifth para, as a fifth line from the of the second paragraph, where the case number, my lord, will finally case that case number 106. There is no year.
No year?
No year. Only case number 106. It should have been accompanied by year. It is first anomaly. Second anomaly, my lord, it is on the very apparent on the face of the report. My lord, on the page 3. My lord, page 3 is Khotian number 98. My lord, at that page 3 of the report, my lord.
Page 3?
Page 3 of the report, my lord. First page is the covering letter.
Right. Khotian number?
98, my lord, at the right-hand corner of the JL number 94, then diagonally, angularly, it's below Moja Uchul jail number 94, the next line, Jila 24 Pargana, Bata number this, Khotian number 98. So, and my query pertains to a different DAG, my lord, different Khotian. My query was about 363 at page 29. of the writ petition.
Not 330, 331.
330 is the DAC number. And Khotian number 360. Para 4 at page 29, my lord. And my lord, once again, I shall seek your indulgence of your lordship to come to the first para of the second para of the of their report, where the ones after 106 paras, determining the nature of consequently the plot is full share incorporated in collector's Khotian. Further, a piece of land of measuring 0.50 with share of 1283 in subject plot appeared to be incorporated in Gratuity Khotian in favor of Joydev Bera, son of Kailash Bera. White case number 201 of 2010. I take it as 2010. Now, my lord, the interesting part is that at page 30 of the writ page 30 of the writ petition, it is their record. Only the Joydev Bera is appearing. Then there are other three persons: Ramsundar Senapati, Anukul Senapati, Vidubhushan Senapati. It is their record.
No, but then the Khotian number is different.
Their Khotian number.
Joydev Bera Khotian is 2283.
2283. Joydev Bera's Khotian is, if Joydev Bera's Khotian is 2283, then these other three persons of the same DAC, Joydev Bera's Khotian is 2233, 2283 has been created by, since he has been, even if he is admitted, assumed that he has been recorded, his name has been recorded in record of rights. A different Khotian has been created. Then these three, how these three persons come into this Khotian, it is not answered.
Does it come on the same Khotian? The Khotian number is different, I can see, for all three. Page 30, see, left-hand side Khotian number is different.
Different Khotian number is different, but it was also my query as page 29. How these the three persons in the DAC number 330, how these three persons name has been recorded. They are citing the name of only Joydev Bera, they can explain. Other than the other three, they cannot explain. And this is since it came out from their application. And my lord, and last occasion, lastly, I will take indulgence of your lordship only on another 2 points, my lord. At the page.
1 minute.
Yes.
Mr. Sen, the report that you handed over on the last occasion.
My lord.
Second paragraph.
Yes.
On careful scrutiny of all the materials, relevant records available, it appears that the subject plot, RS plot number RSLR 330.
My lord.
Is this the plot that you require information of?
330.
Classified as Bilan. It's measuring such and such and full share is vested to the state. Case number you have given, but the year has
mentioned. No year mentioned.
So it is an incomplete data. And see, then next 2 lines, further a piece of land at measuring such and such acre with share such and such in subject plot appears to be incorporated in Rayati Khatian in favor of Joydev. Case number has been given on the strength of such and such, but erroneously, equivalent share has not been debited from the collector's Khatian. So this is an inconsistency. Instead,
no, this is not inconsistency. If first of all, may I, whatever, my lord, I myself, my lord, already, my lord, I have understood on the basis of this, because I have not interacted with that, my lord, the gentleman till, but I have gone through this report. First of all, he has to file an exception. May I tell you why?
The prayer, my lord, let us just, my lord, concentrate ourselves only the prayer. Prayer is that Reati plot is the number 330, Khotiar number 360. And the information short whereby the names of outsiders have been recorded. Information short that how
Outsiders'
names have been recorded in this. First of all, this is not a public interest litigation, number one. Number two.
Where does the public come in?
I'm coming one after another. Number two, if it is an admitted fact, if the writ petitioner admits to so far extent this information disclosed herein or unearthed herein, that plot number 330 classified Bilan in Moja such and such, entire plot vested in the or with the state of West Bengal. If the entire plot vested with the state of West Bengal, if that is not denied, then whether the rest of the information he is entitled to or not. Then if somebody's name, how, my lord,
is the entire plot vested?
As it appears. If your lordship kindly have a look, in a full share, measuring 3.90 acres, in full share is vested to the state on the strength of relevant provisions of West Bengal State Acquisition Act 1953. So if the entire plot, entire area, entire land that is vested with the state of West Bengal, then first of all, he has to deny it that no. Then the rest of the answers, yes, I am supposed to answer. And that is why I say that this is not a public interest litigation. That how with the, my lord, the government land, somebody's name has been, my lord, crept into.
P302.
People also kindly have a look. Page number 31, annexure P7. It is he, my lord, relied upon and or annexed a document. It is also, my lord, informed by BL and LRO of that, my lord, the particular, my lord, the having his jurisdiction. And that was the reply in respect of RTI application, page number 31. Reply to his...
Page number 30. Look at page number 30. This is the record of rights. Right?
No. I am coming to the report again, lordship. Kindly come to the report. It has been
Page
explained
number
here.
30 is your document.
That is the report considered it, and report says yes, there is some discrepancy. It has to be gone into any further.
Right.
Report
So
says,
there is
moreover,
discrepancy.
Can you allow me to read it?
You say on what
However, in
fact?
the updated computerized land records, there exist some serious inconsistencies. Yes, it is admitted.
Then where from?
With respect to total share of the subject plot, which requires further inquiry and careful scrutiny of record of rights and relevant Moja maps. So prepared.
So there is errors. It is erroneous. Why I tell you, page 30. The area is 3.90. Page 30.
Yes, page
right
30.
hand side.
Yes.
Your information says 3.90 is vested to the state. If 3.90 is vested to the state, how can the riot's name be recorded over there?
That is, my lord, exactly, my lord. It is, my lord, the gray area is, my lord.
Not
it has
gray.
Been mentioned
It is
area.
absolutely black. Not gray. It's totally wrong. It cannot be. If the entire land is vested to the state, how can riots be there?
So that is also, my lord, the question put
It
here
cannot
also
be.
in the report also said that some time
You
is required.
file, yes, you file a proper report. The case number is not given. It is the under the estate acquisition it has been taken, so the big riot case will be there. The year has to be mentioned.
Oh, yes.
Absolutely incorrect. Please come. Peruse the report filed by the Blockland and Land Reforms Officer Minakha, dated 13th of March 2025. Stop. The report mentions of several inconsistencies. Stop. The said inconsistencies are evident on record. Stop. The record of rights annexed at page 30 of the writ petition is completely contrary to the instruction forwarded by the Blockland and Land Reforms Officer. Stop. Next. In view of the above, the Blockland and Land Reforms Officer is directed to take immediate steps.
No, my lord, he prayed some time, Lord. You kindly have a look, my lord. It's
Yes,
an
yes.
he admitted that there are some mistakes on the computerized, my lord, the land records.
The said last line just. The said officer has sought time to rectify the errors. Stop. In view of the same, hearing of the writ petition stands adjourned till 6th May 2025. An updated report shall be placed before this court on the adjourned date.
Fine.
একটা 15 কি ডাকবেন? ডাকুন।
Get.
রিট নম্বর তো নেই, নম্বরটা দেবেন। রিট নম্বর না দিলে কি করে হবে? এই তো রিট পিটিশন নম্বর আপনি এখানে পেয়ে যাবেন। হ্যাঁ, আর অর্ডারটা দেখবেন, মেন অর্ডার শিট থেকেই তো আপনি পেয়ে যাবেন। রিট ফাইল নট অ্যাভেলেবল, একদম, তা নাহলে পরে Learned advocate for the petitioner submits that the contempt application has become infractuous. Step. In view of the same, the same stands dismissed as infractuous.
Well, 325 also, my lord.
Same.
Okay.
326, 327, 328, 329, 330, 331, 332, 333.
Well, I am for the petitioner.
Yes.
The first time appearing, my lord.
From 2014, is the
They-
contempt application
they have
still
filed
alive?
They have filed the appeal against this order.
And
the appeal dismissed.
appeal has been dismissed.
I am paying for serve the copy to the content.
Very well. দেখি ফাইলটা। বলে দিয়েছে। Read. দিয়ে দেবেন, কারণ রিটের নম্বরটা না দিলে তো কন্টেম্পটা কোত্থেকে এসছে সেটা বোঝা যাবে না। হ্যাঁ, এটা কতদিন আগে দিয়েছে জানেন? The order is dated page 19, 21st August 2014.
Yes.
Right.
They prepare an appeal on appeal dismissed on, my lord, 6th December 2023.
Exempted category.
Yes, my lord,
To be
the land
enlisted.
user, my lord,
Land
apply for
user's
the
case.
exempted category candidate, but not denied because he's the, my lord, the married daughter. Subsequently, the memo has been set aside by this court and directed to recorded her name as exempted category. Challenging that order, my lord, appeal was preferred by the government. That appeal was dismissed, but no step has been taken till today.
Why did you not take steps for getting this matter heard?
But due to pendency, the appeal, my lord,
When was the appeal dismissed?
Lord, December 2023, my lord.
December 23. The officer must have changed in the meantime.
No, I just taking the information, the same officer is there.
Director of Employment is the same person. From 2014, 10 years, he is holding the same
My lord,
post.
just now I getting information from the office, my lord, the Amarnath Monlik is the present in Calcutta.
First day, serve list on আজকে তো হচ্ছে 20 তারিখ 10th of April.
Get.
Yes.
$335, my lord, I am for the applicant and I'm seeking leave, my lord, to incorporate the new incumbents, my lord, the municipal commission.
Is the
yes,
contempt still
because
alive?
my lord, there was an order of status quo passed by this honorable court. My lord, in violation of that order of status quo, they demolished, my lord, 2 advertisement structures, my lord. Now, the writ petition is still pending, my lord. And my lord, there are 3 contempt petitions. This is one of them, my lord.
All right. Leave granted, file. Leave granted to the advocate on record of the petitioner to implead the present incumbent as contemptor / respondent in the contempt application and serve copy of the contempt application upon the added party. Which one? Both?
Both.
দুজন আছে. Returnable 10th of April.
Great.
যেগুলো অর্ডার হচ্ছে না রিটার্নেবল
336.
Are you aware, Mr. Mukherjee? কোথায় গেল? Are you aware where the writ file is? The writ is pending, you say?
Yes, my lord, that I can ascertain and my lord inform.
Because the writ file is required to be brought.
Yes.
All right.
336. 337.
337, Lordship, I'm for the petitioner. Lordship, for a long time, Lordship, the petitioner didn't contact with us, Lordship, my client, Lordship. So allow me 2 weeks time, Lordship. I don't know whether in the meantime the order has been complied with or not.
On the prayer of the learned advocate representing the petitioner, hearing of the contempt application stands adjourned till 3rd of April, 2 weeks.
Lordship.
In this matter, I am appealing for the alleged contemptor, though the DI has already returned new and it has been complied with, my lord.
Order has been complied?
Yes, ma'am.
None appears for the petitioner at the time of call. No accommodation sought. Stop. Learned advocate representing the contemptor submits that the order of the court has duly been complied with. Stop. Copy of the memo dated 5th January 2023, issued by the District Inspector of Schools, Secondary Education, South 24 Parganas, be retained with the records.
Along with the memo.
Along with the PPO.
PPO issued by the
EPPO issued by the DPPG be retained with the records. Contempt application stands dismissed.
340, 341, 342, 343, 344, 345, 346, 347, 348, 349, 350, 351, 352, 353,
I'm for the applicant, subject to correction, whether my lord will take up this matter, order passed by late Justice Banerjee.
These matters are assigned to this bench.
There is no rider of the assignment of.
No, there is. Specifically, there is an entire bundle which has been assigned to this bench for taking up. So that way there is no issue. If your contempt is alive, then the court can take it up. If it has died in the meantime, then nothing doing.
That specific rider has been given to Justice Bhattacharya.
That is separate. That is separate.
And this coming from the department.
This is coming from the Chief Justice's office.
Oh, then I am safe. Another day. No new incumbent has come.
No new incumbent.
New incumbent has
come. All right. Leave is granted to the advocate on record of the petitioner to implead the present incumbent as party respondent in the instant contempt application. Stop.
And service.
Did you serve?
Yes. No, I have to serve again.
Achha. Let the copy of the contempt application be served upon the present incumbent. Returnable on 10th of April.
10th. I am afraid of the latest judgment of the Honorable Supreme Court. That master of roster is to be.
No, it is from the master of the roster.
Now, Justice Datta has not clarified the issue from.
No, it's all right.
Much obliged.
355, 356, 357, 358, 359, 360, 361, 362, 363, 364, 365.
My lord, in this matter, 365, I appear on behalf of the applicant, my lords. So, my lord, this after my coming in the list, my lord, I served the notice upon the alleged contempt. So now server report, but because of the last, my lord, the Monday I have served.
How could you serve without a direction from the court?
There was a direction.
There was
in 2020. So, my lord, there is the out of my lord, the 7 legal years. The payment has been made in favor of the 4 legal years. Because of
in the contempt, there is no order.
No, I have not served the contempt notice because of the during the pendency of this contempt application, they have released the major portion of the money in favor of the legal years. So now some mismatch of the bank account, the remaining portion has not been credited in favor of the some petitioners.
So this is a fresh cause of action.
No, because there was a direction to release the premature death cum retiral benefit in favor of the legal years. So now they have paid only 4 the legal years out of 7 petitioner. So now remaining portion that has not been in spite of spelling mistake, whatever it may be, and
Where will you serve in that case? Is the person the same?
So that's why I pay for adjournment for 1 week. Again, I can, because of this learned advocate who is supposed to appear, Mrs. Mukherjee.
Appear for whom?
The alleged contempt. He told me after the service the notice. She told me she will take the instruction. Then
all right.
So adjourn for 1 week.
Allow the learned advocate representing the petitioner to take proper instruction in the matter. Release the same next Thursday.
Next Thursday.
27 তারিখ
ও রিটটা সে তো চলে গেছে খিদিরপুরে
নেক্সট থার্সডে
আমি দেখছি আমি
Lord, I appeal on behalf of the petitioner. Am I audible, my lord?
Yes, I can hear you.
My lord, this is a contempt application, my lord, of your lordship's order, my lord. My lord, the order is at page 26 of the contempt application, my lord.
Compassionate appointment, it is pending from 2022.
Yes, my lord. My lord, if my lord kindly allows me to apprise your lordship as to what had happened, my lord. My lord, this writ petition was disposed of in the year 2022, my lord. Subsequently, my lord, there was a change in brief, and the same was, if my lord kindly takes up page 28 of my application, the same was communicated, my lord, by a lawyer, Mr. Akhil Chandra Adhikari, on 12 in 2020. Subsequent to thereafter, Millard will see the Millard. There is no date on that letter, Millard, on page 28. If Millard kindly takes up page 29, Millard, these are the postal receipts, Millard, on page 29 of my application. Corner, these are the postal receipts, my third line, Millard. Millard, we'll see the date, Millard, the date in 2022, Millard. On 12 to 10, 2022, the order was communicated, Millard, and since then, Millard, there is no hearing or no opportunity has been given to the petitioners, Millard.
See, the order was dated 10th of March.
Yes, my lord.
Time was given for a period of 8 weeks. And you
yes, my lord.
This order in the month of October.
Yes, my lord. The order says that the writ petition, but from the date of communication of a copy of this order, my lord. My lord, this communication was done, my lord, on. Yes, my lord.
That does not mean that you will communicate the order whenever you feel like.
My lord, my lord.
Then?
My lord, there was ultimate. My lord, there was, my lord, due to improper legal guidance, my lord, this had occurred, my lord. My lord, my lord, there has been several change of briefs in this matter, my lord. My lord, the writ petition was filed by a different advocate, my lord. Subsequently, there was another change of advocate, my lord. There was then another advocate, my lord, came up filing the contempt application, my lord.
Where will you serve notice? First day?
My lord. Grateful, my lord. Grateful, my lord.
Then you are delayed. If an issue is raised with regard to the maintainability, be prepared.
My lord, I am prepared with that, my lord.
Returnable Korodin, 10th of April. First time.
Grateful, my lord. Grateful, my lord.
Are the contemners still in office?
Yes, my lord, they are still in office, my lord. So far as my knowledge is concerned, my lord, so far as my instructions are concerned, my lord, they are still in office.
The chairman of the municipality has not changed.
That I have to take instructions now.
Yes, obviously. May click on municipalities to take a decision. Please check up.
My lord, my lord. Yes,
For the petition. And I appear for the added alleged contender, that is contender number 2B.
Added?
Yes, no, last order, your lordship, kindly once peruse your lordship's last order, that will be.
Finance was added.
Finance, the principal.
Because Lord, the submission was made that they are reconsidering the proposal with regard to whether I am entitled from the date of initial appointment or not. So once they have decided that that should be from the date of initial appointment.
A report from the additional chief secretary was directed to be placed. What does your report say?
Lord, we have given approval. We have
approval from which day?
From retrospective date, my lord.
From the retrospective, that
Lordship,
means their
kindly-
grievance will be
Lordship,
redressed.
there are two reports with regard to two different
Please circulate, let them go through it.
Circulate,
Why two reports?
There are two contempt applications.
Two matters.
আমি ভুলে নিছি
671, 672.
দাঁড়া দাঁড়া
Very well, please come.
Only one.
Report of the additional chief secretary.
Our report is also there. What,
Please give.
what we have done. So far as the municipality concerned, I am serving them.
Matter below 49. I am appearing on behalf of the superannuated employees. Your Lordship kindly takes the order dated.
1 minute. Is it CPAN either 671 or 672? No. Which one?
672.
672, a report is also there. It will be, copy will be circulated.
Yes.
Go through it.
But I am on the separate issue altogether, Miller. Your Lordship kindly takes the 9 January.
In that case, let me finish with 671. Yes, Mr. Banerjee, what is your submission?
My submission is that we have filed a report regarding that. How many names we have sent to them, how many names are yet to be sent, that is specifically written in the table.
All right.
That is there.
Report of the additional chief secretary, finance department. Filed in court today is taken on record.
So we don't know.
11565 for type of the
Acha, signed on করে দিন 11th March 25.
no 20
Let copy of the same be circulated. Stop. Next Thursday, I'm keeping it.
Yes,
List next Thursday.
give some precedent.
Yes, yes, it will remain at the top. Acha, এটা 671. Acha, এটাও রেখে দিন. Report of the Howrah Municipal Corporation.
Is also circulated.
You've got single report for both.
Both.
আচ্ছা, ঠিক আছে, তাই. Let it be taken on record.
Well, I am sending for the 2 files.
Yes, 2 files, 2 copies. It will be nice. Yes, পরেরটা দেখি তো. 672. What is it?
Yes, Miller, Lordship kindly takes the order dated 9 January 2025.
Yes.
Lordship kindly takes paragraph 7. Lordship has recorded that the EPPO, there has been a direction to adjust, and Lordship restrained them. They are still adjusting.
This must be done by the DPPG's office. Who is adjusting?
Finance department.
Finance, once it is clearance is given, does the finance have any role?
No, my lord. I think, my lord, the
I
DP,
also
Lordship
don't
was rightly
think
pointed is from the DPPG's office.
DPPG's office. It has to be. Now, DPPG is not a party. See, they have in principle allowed your prayer. So even if there is any adjustment, that will be taken care of. You go through it.
So,
Yes, Milord.
Yes.
I assume so.
Restrict our submission, Milord, after Milord this.
And Milord, one more point is there. If your Lordship takes Milord the supplementary affidavit, since Milord I am a superannuated employee, Milord, I am feeling the pain, Milord. Lordship kindly takes Milord the supplementary affidavit which has been affirmed by us. Kindly
Yes.
takes Milord page 14 for once, Milord.
Yes.
Before that, your Lordship kindly takes Milord page. Yes, page 14, your Lordship will find from the pension, the amount is 20,337. ROPA 2019.
ROPA
amount is
2019.
337.
Amount is, where do I get the amount?
আমার কাছে নেই supplementary আছে আমাদের কাছে
2337.
Yes. Now, my lord, if your Lordship kindly takes my lord page 13 for once, your Lordship will find, according to them, I have been absolved, my lord, from 2003.
All right.
Now, my lord, the difference from 2003 till my lord 2020, it has to be my lord given.
Go through the report. Then make
But
submissions.
This is only with
next
regard to
day.
the area, my lord.
Yes.
Because
I've
my lord,
followed.
I am feeling the pain because
I
I have been
followed it.
superannuated, my lord.
Yes,
Some
yes,
of
I
them,
have
my
followed
lord,
it.
I will
The
also
moment they give you benefit retrospectively, you will be entitled to everything.
But that is admitted in over here, my lord. They give, according to them, as on date, it is from 2003. So if it is, my lord, according to them, admitted from 2003.
Is that the initial date of appointment?
According to them, this is, my lord, page 13, which they say.
Your initial, what, according to you, what is your initial date?
It's from, my lord, from 1988.
88,
In
they
one of the,
say,
my lord,
Mr. Siddiqui says they'll be giving you retrospective effect from 88 or from 2003?
that
from
is, my lord,
2003, my lord.
question.
But what I am on, my lord, to ameliorate the sufferings and pain of my dear friend. He has
Yes.
used the expression pain. Can I be served with a copy of the supplementary affidavit?
Certainly, it
Right,
will
so
be.
that I can understand, my lord, because
Yes,
I am
yes,
just added,
certainly,
so that I can
certainly. Give
understand what
copies.
his pain is.
We'll serve them. We'll serve them.
Same order, next Thursday. Let us see.
Grateful.
হ্যাঁ দুটো রিপোর্টই আছে
ইনিশিয়াল অ্যাপয়েন্টমেন্ট দিতে চাইছি দেখো তো ওটা পড়ে না তো আচ্ছা তোমাকে দুটোই রিপোর্ট দিয়েছি একটা তো ওদের কন্টেম্প না তো এর কাছে তুমি কোনটা আছে ওদের তুমি দেখবে আমি বুঝতে পারছি না
কি জন্য
Your Lordship, I am appearing for the petition in this matter. I am being led by Mr. Shomu Majumdar, Your Lordship, learned senior advocate. Your Lordship, petitioner is aggrieved by the letter dated 10th February 2025, issued by the respondents, Your Lordship. It is at page number 32 of the writ petition.
Page
32, Your Lordship.
32 of the writ petition.
Your Lordship.
বাইরে কে চেঁচাচ্ছে মানা করুন তো কি চিৎকার করছে
Your Lordship, a fresh copy is here.
Please use the microphone.
Your Lordship, a fresh copy is here, Your Lordship.
No, page 32 is there. I can read it.
A fresh copy is here for Your Lordship.
It's not required.
On her. Lordship, they are only verbally told that it will be taken up. No physical notice or nothing. Lordship,
But then you have been intimated.
my lord, during course of the day, without any copy, I don't know what application they are even
An
moving.
application was served upon the department further.
Then serve a copy upon
Your
him.
Lordship, I am serving.
Do you have a copy of the writ
No, my
petition?
lord. Writ petition I have, but it has not.
Application you do not
No,
have.
no.
Take a
I'm
copy.
serving.
What is your prayer?
Your Lordship, my bank, they have issued a letter invoking my bank guarantee, Your Lordship, that they will invoke my bank guarantee. So that may be stayed, Your Lordship.
For invoking the bank guarantee.
Your Lordship.
All right, tomorrow it will appear at the top.
My lord.
Please take information instruction.
But
Urgent motion.
Can it be on Monday, my lord?
Your Lordship,
Because
has already issued a letter, Your Lordship, on 10th of March.
I do not
There's
know.
extreme urgency.
The court doesn't have any urgency. It is the urgency of the petitioner. You are
can it-
taking steps for
they are supposed to, as
invoking.
because it was item number 1566, department is supposed to come before on just senior on Monday morning. Can it be on Monday, at least Monday 2 p.m., my lord?
Very 2 p.m.
Okay, Monday, anytime Monday, my lord.
But then do not invoke the bank guarantee in that case.
That I don't know, but in the morning, what they submitted, that forfeiture was done after they filed the motion. But that is not the thing. It was done on 10th March when they have supplied the writ petition on 25th of February. It was done on 10th of February.
Your Lordship,
Whatever, my lord,
the
I'm not
letter
going
was
into the
Bank
details.
guarantee. The petitioner's apprehension is that you will invoke the bank guarantee, right? Please do not do that till Monday. I'll keep it on Monday.
My lord wishes to take it up tomorrow, my lord.
It is not wishes. I wish to take it up now only.
My lord, kindly then tomorrow, my lord.
If this is your prayer, then tomorrow.
Okay,
Yes.
grateful, my lord.
Urgent motion.
Obliged, Your Lordship.
In this matter, Lordship, I am for the petition. Last
Yes.
petition, Your Lordship, please to issue the rule against the Panihati Municipality, Lordship. Now, we have taken an instruction, Lordship, 2 or 3 days back. The chairman, Lordship, has resigned.
Resigned?
Many allegation against him is sold a government field. Now, rule issued, we have, Lordship, already deposited the cost for the rule.
Yes.
The order.
It has been served.
Yes.
Now, if the person concerned has resigned, then who was the learned counsel representing the municipality?
None appears at the time of Lordship. The writ petition was disposed of. None appear for the
Who
municipality.
usually appears? In this matter? I could hear you from outside, so I thought you were there.
Now the municipality is running without any chairman. The board of councillors are running the.
What is your prayer?
Prayer, Lordship, initially an demolition order was passed. That was partly, Lordship, complied with by the concerned municipality. Thereafter, no steps for demolition was taken. Thereafter, Lordship, the writ application was filed. Your Lordship directed the said demolition to be completed within a stipulated period. After expiry of that period, Lordship, we have filed this contempt application. Service completed. Last occasion, your Lordship was pleased to issue the rule.
Ashunta, none appears. Now, neither the contemner appears nor any advocate appears on behalf of the contemner, despite service of the rule. Stop. Learned advocate for the petitioner submits that the chairman of Panihati Municipality.
Lordship, it is Lordship, I am praying not to record that much submission because I have instruction, but whether that has been accepted or not.
But then you say he has submitted his resignation.
Resignation because the authority, Lordship, asked the petitioner to come at their office.
Very well. কি বললাম? সৌম্যজিৎ ভট্ট অ্যাপিয়ার করতো না? Do one thing. You inquire from Mr. Shomujit Bhatto whether he appears for Panihati Municipality or not.
Yes,
Right? I'm passing it over for the time being. Inquire and let the court know. Otherwise, I'll issue notice upon the Secretary of the Municipal Affairs Department.
I thank you, Lordship.
Acha.
Phone number?
Yes. Madam, I beg to appear on behalf of the contemners, my lord. My lord, rule issued, my lord. Both the contemner number 1 and 2, my lord. They are present before your ladyship, my lord, along with the ADM also.
My lord, is the kindly come to Lordship's order of 4th of October 2023. Your Lordship has considered the report of the PLRO. Then your Lordship passed the necessary order because of that unauthorized construction on water body. So now that report has been called for by your Lordship. Considering that report, your Lordship necessary direction has been passed. Kindly come to Lordship's order on 4th of October. Rather, my lord, without my lord initiating any proceeding against the person who has, my lord, directed to remove or remove.
1 minute. Are you, Pania, you are representing both?
My lord, I am representing both, my lord. The contemner number 1 is the erstwhile, my lord. He has been transferred to another place, and the contemner number 2 is the present, my lord. And my lord, what my friend is addressing to your ladyship, my lord, there was a direction to adjudicate the issue by the BLLRO officer Mathurapur 1 South 24 Parganas to cause spot inspection upon prior notice to all the necessary parties, my lord. My lord, the contemner number 1, the erstwhile BLLRO, my lord, he has done it, my lord. We have prepared one affidavit of compliance for your ladyship, my lord, to satisfy your ladyship, my lord. My lord, it has been done in due course, my lord. And my lord, the contempt application, if your ladyship will see the prayer portion, my lord, they have said that the illegal construction has to be demolished, my lord. My lord, first we have to ascertain whether it's illegal or legal, my lord, as per the direction of your ladyship.
Or not? The order was in October 23. Has the ascertainment been made?
My lord, everything has been done, my lord. My lord,
conclusion?
My lord, it is an old structure. We have found with the private respondent number 9, my lord. We gave, my lord,
report of inspection. Report of inspection.
My inspection, everything is there, my lord. In my affidavit of compliance, my lord, your ladyship will find the annexure A1.
Page 15 in my contempt petition, kindly see nothing, nothing submission is required. Lordship considered the page 15 order.
No, page 19, page 19, 2nd January 2024, there was a direction for spot inspection. For a hearing, 22nd of January, page 19 in the contempt. This is a hearing notice. What transpired thereafter?
In hearing, my lord, the private respondent number 9, they made an application for convert. My lord, this is my affidavit of compliance.
I will not travel. I am not.
My lord, if your ladyship will come to the very first page of the annexure, my lord.
Because of that only, kindly see Lordship's order only. Because of that earlier, then they have come with the fraud before this court, played with the before this court. Because kindly see the lordship's order. Otherwise, I will not open my mouth. Kindly see, my lord, the learned advocate appearing for the state respondent has obtained instruction from the block land and land reform officer Mathurapur 1, South Chobis Pargana, wherein it has been specifically mentioned that on the inquiry, it was detected that the DOBA appearing in plot number such and such. Fill up. The block land and land reform officer Mathurapur 1, South Chobis Pargana, by communication dated 7th of August 2023 has intimated the private respondent to restore the DOBA. That means report after inquiry, they have filed a report before your lordship.
I'm requesting my friend to kindly read the next paragraph, my lord.
Next paragraph, prima facie on perusal the report filed by the block land and land report Mathurapur South, it appears that DOBA has been filled up for raising the construction. Now today he has come. Today he has come.
Then thereafter, there is an observation of your ladyship to advocate the issue. The BLLRO Mathurapur 1, South 24 Patna is directed to cause spot inspection upon prior notice to all the necessary parties to ascertain as to whether the construction in question has been made over a water body or not, and thereafter grant an opportunity of hearing to the petitioner and the private respondent and all other parties, including the Pradhan of the Gram Panchayat, my lord. Thereafter, my lord, after passing of this order, my lord, we initiated the proceeding on 25th of December 2023.
You go through the compliance report and come back.
Not, sir.
My lord,
Go through it.
Kindly come to
they
next.
filed with the
My order.
I asked him to dekhi.
So, my lord, this is the absolute. They have not.
Affidavit of compliance filed by the contemptor number 2 is taken on record. Stop copy of the same has been served upon the learned advocate for the petitioner in court today. Stop. Release the matter on 17th April.
Well, next week.
Maybe
Exception to the same may be filed prior to the adjourned date.
Absolute
rule may be discharged.
Because of the lordship, consider their report inquiry.
Rule was issued.
Yes.
Yes, my lord. They both the BLRO, my lord, as well present BLRO along with the ATM, all are present, my lord, before your ladyship, my lord.
With the political, they have corrected the record of rights after.
And the lady is the present BLRO.
All right.
My lord, it should not be, my lord, this is dispensed with the rule. Because of that, I know, my lord, very well. They have called my client and corrected his record of rights. Then
they are interpreting your ladyship's order in a different manner.
I'll hear it. The contempt, take down the names of both give the names and the designation. Are personally present in court in response to the contempt rule issued. Stop. Their personal appearance stands dispensed with for the time being. Is it a fact that the record of rights was corrected after?
Original.
My lord, the deed has been executed in 1980, my lord. The father of the private respondent number 9, he purchased the land, and in 1980, where
the land is recorded as DOBA, and then it is being used as homestead.
Your lordship, the thing is that in 1980, the conversion rule was not present. The conversion rule came much later on in 1886.
1991.
Now the land was purchased as homestead in 1980. And all the elderly people, they have also submitted a written letter to that this has been persisting since 1980s. And also, we have also annexed the deed therein.
How come the BLRO on the earlier occasion filed a report that the construction was made over a water body?
My lord, this deed was not presented before the BLRO.
Mud hut. And the mud hut became the mud hut was a bit kind of destroyed in the Amphan, and that was reconstructed, that was repaired. No new construction was there. The construction was there. In the inspection, it came to the notice that yes, there is a construction over there, but afterwards we received the deed of 1980s much later during the inspection that was done after your ladyship's order was passed.
Very well, I'll hear it on the next day. In the meantime, you can file your exception. Yes, the next one.
370. In 370, my lord, I appear for the petitioner.
Yes.
My lord, your lordships, my lord, by the order, I stated to have
Who is your other side?
Lord, in terms of your Lordship's order, my Lord, I have communicated your Lordship's order. The affidavit service, you have duly received it, my Lord.
West Bengal Comprehensive Area
Area
Development
Development
Corporation.
Your Lordship may kindly turn to page 30 of the petition, page 30.
Let me ensure for the presence first, then the next step.
My Lord, your Lordship
Was this
pleased to
authority,
What do you
was
think, my
this authority represented in the writ petition? In the writ petition stage,
Yes.
they were represented?
Yes, in their presence, the petition was disposed of. Your Lordship was pleased to direct the administrative secretary to forward my application to the competent authority to decide the same for grant of extraordinary leave. Instead of doing so, he himself decided it. I have stated, my Lord, page 38. Page 38. He himself decided. He lost his specific direction that it should be forwarded to the competent authority, that is the Honorable Governor, under Rule 34 of the WBSN. Your Lordship's direction was to forward my applications with medical certificate. Then I, my Lord, requested him to recall and forward the same to the competent authority. He did not. In the way, my Lord, I am deprived of my pension even if I am not getting pension, even in the age of 70.
None represents the contemner. Stop. Let contempt rule be issued. Returnable on 10th April.
10th April.
Affidavit of service is taken on record.
Sir.
Grateful. I actually appear on behalf of the applicant, my Lord. This is a contempt petition, my Lord. For my Lord, willfully and or deliberately, my Lord, violating, my Lord,
This matter, my Lord, I am appealing for the Kolkata Municipal Corporation.
In a contempt, there is no corporation. There is a particular person. Who is the contemner?
my Lord, the Municipal Commissioner, the Director General of Building,
all right,
the Executive Engineer Building Department, and my Lord, the Deputy Commissioner of Police.
Where is the order?
Port Division. My Lord, will find the order
Page 28.
at page 28, my Lord.
I am only praying, my Lord, one copy may be served, my Lord. I have not received, my Lord.
We had
Yes, my
effected
Lord.
service, my Lord. My Lord, may I file the affidavit of service, my Lord?
I have not, my Lord. Maybe
Today,
they have served, my Lord.
Well, first time, my Lord, I am praying for, my Lord, issuance of a rule. My Lord, lastly, what happened was they came up, my Lord, the private respondents, they came up seeking modification. Modification,
yes, respondent number 6 filed an application for modification. The same was dismissed.
Yes. But despite
was
that,
any appeal preferred?
My Lord, not to our knowledge, my Lord. Various writ petitions were preferred, my Lord, filed. Those were dismissed, my Lord. Thereafter, this modification, sir, just a second, sir. Thereafter, this modification application was filed. This modification was rejected, my Lord.
Yes.
My Lord, as on date, my Lord, I have annexed photographs, my Lord. The unauthorized building stands. G+3, my Lord. G+6, my Lord.
Completely unauthorized or partly unauthorized?
Beyond the third level, everything is unauthorized. My Lord, the photographs will find. My Lord, will find the photographs at page 41. And also at page 30. The special officer building passed an order to demolish the additional construction above
Very well.
3-story.
It's served notice.
But notice has been served, my Lord, but I am praying for issuance of rule, my Lord. This is what
notice has been served. How could it be?
Copies were, my Lord, served in advance, my Lord.
How? Prior to the court entertaining the contempt, you go and serve?
I understand, my Lord.
Then it cannot be taken.
Oh, no. It was mentioned for upgradation and according
that notice has been served.
Yes, yes.
Please come. First day appearance.
My Lord, kindly issue a rule, my Lord.
No, not on the first
this
day.
is being deliberately done, my Lord.
Not on the first day.
Very
and moreover, when somebody has is entering appearance.
Very good.
I appear on behalf of the contempt.
The corporation is here, my Lord. the corporation, alleged contempt, my lord, of the corporation, my lord, is being represented. They can also be, my lord, directed to file a report.
Yes, yes.
The copy be served.
Copy এখনই দিয়ে দিচ্ছি. I'm serving them right now. একটা copy দাও, তোমার copyটা দাও. হ্যাঁ.
Serve copy.
I'm serving copy right now, my lord.
Returnable 17th April. Affidavit of compliance shall be prepared and circulated prior to the adjourned date.
হ্যাঁ, হ্যাঁ,
ওইটা দেখে নাও।
হ্যাঁ।
ঠিক আছে?
17.
ঠিক আছে?
Acha, additional copy upon Shushmita Mukherjee.
Right, instead of 17th, my
Chatterjee.
lord, may it be on the 21st or my lord, any day.
24th.
24th.
24th. 24th তারিখ। Upon Miss Shushmita Chatterjee, representing the officers of the Kolkata Municipal Corporation.
But I have served her. Great. But let a report be also filed on there by them.
Affidavit of compliance will be filed.
Great, great.
And if it is not complied, you know what is going to happen.
My lord, I am appealing for the private respondent.
They are not
A
good
contempt?
parties.
Not a contempt. My lord, I was a private respondent. The issue is that the appeal was filed.
Yes, what happened?
Now thereafter, my lord, the section 5 has been allowed. And the
All
matter has
right.
been fixed on 7th of May for hearing of the stay petition. Now, my lord, in between the KMC could not take steps as due to, my lord, there was an order passed by a division bench as because till the quorum was formed.
But
So
this
this
is
is
not for modification, my lord. Citing these
quorum
grounds,
was,
the modification was
my lord,
dismissed, my lord. They're trying to,
No,
my
no,
lord, reopen the case.
then what happened?
my lord, till the quorum was formed, this would operate as a stay order on the demolition proceeding. Now, as soon as the quorum was formed, we moved that application challenging the appeal, my lord, challenging that demolition order. My lord, the section 5 has been allowed. My lord,
By the tribunal?
by the tribunal.
All right.
This is the
No, I do not want to see anything.
no, my lord, this is the
The date is fixed on 24th.
no,
Whatever
this is
will
the
happen will
this
happen.
is the information slip.
You go and take steps before the tribunal
Because,
for
my lord, the
preponing
matter
the
is fixed
matter.
on 7th of May.
Prepone it. Yes,
My lord,
next.
Because, in fact, my lord, I have the entire order sheet.
my lord, I'll keep
18th of December 2024, their prayer for interim stay, my lord, has been rejected, my lord.
Yes, call the next matter. Why? Why are you praying for not today?
He asked me, he is a leg on the other court. If he could not present in the at the time of holiday, that is why I'm praying. At least the password, madam. Let him.
For the petitioner?
Yes, madam. Mr. Sikanta Doctor is appearing.
Yes.
Passover, otherwise, he is leg on the other court, madam. He told me, that is why I'm praying people, lordship. Otherwise,
An accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. In view of such prayer, list on 17th April.
One indulgence, lordship, may I? I have accepted to lordship, bring Mr. Bhatt.
In this matter?
No, item 368, your lordship.
368 is long over.
Yes, lordship, your lordship asked me the Mr. Somodhi Bhatt.
Yes, Mr. Bhatt, Panihati Municipality. Are you there?
Yes. No copy has been served.
Who said? Copy has been served.
I called the officers.
There is a report. Copy has been served. Your officers are not telling you the proper facts.
Probably the orders.
The rule has been issued.
Order has been challenged with the division bench.
Show me something.
Next week.
Who are you for?
I'm for the petitioner.
Private respondent challenge though.
Private respondents challenge the, are you aware?
No.
Then?
No copy of the appeal, lordship, as per their version, the appeal also disposed of.
Can you fix next question? If anything.
Acha, it 368. লিখুন তো none appears on behalf of the contemptor nor the Contemptor is present despite issuance of the contempt rule. Stop. As per the direction of the court, intimation was given to Mr. Shomojit Bhatto, learned advocate, who usually represents Panihati Municipality before this court. Before the court. Stop. Mr. Bhatto, learned advocate, seeks time to take instruction. Stop. On such prayer, released on 3rd of April, fortnight's time. The instruction is that chairman has resigned.
He is not holding the chair.
See what can be done. Otherwise, again, Secretary Municipal Department notice has to be issued. Unauthorized construction. Yes, next.
I appear on behalf of the manager. Mala, this the lordship's order. Mala, a demolition order has been passed by the authority concerned 2012. Then, my lords, they prefer an appeal tribunal. Appeal dismissed. Then I came before this honorable court. Lordship delivered the judgment on, my lord, 6 June 2023. They have tested before the division bench. Division bench observed that since the demolition order has been passed in 2012, now you are filing one after another just to delay the tactics on the part of the promoter. So now, in spite of specific directions, police, now the last occasion, corporation has come before your lordship saying that the police is not giving Mala adequate help. That's why we are now completed the Mala the demolition, Mala the work. Kindly come to your lordship's observation, specifically directed.
What is your submission?
Ma'am, kindly come to the last order, my lord, of page 20 of the contempt application, my lord.
Yes.
The lordship was directed, my lordship, my lord, as it appears that the KMC has already requested for providing police help for vacating the subject premises. Accordingly, the Deputy Commissioner of Police, being respondent number 5, herein is directed to take steps for vacating the subject structure and intimate the date of vacation to the KMC so that the main agent of the corporation may remain present on the spot and the demolition can continue. But my lord, we have wrote a letter to the police, my lord, for vacating, my lord.
So,
but my lord, they have not done yet,
I
my
have
lord.
served
My lord,
twice.
this is the last.
Number 2 and 3, police.
My lord, this is the last communication, my lord. Earlier communication, my lord, I have asked.
Mother, 3. Deputy Commissioner 3. Contempt number 3.
This is the last, my lord. But earlier communication I have asked for, my lord.
Did you serve the contemptor number 3?
Yes. Again, my lord, I served. My lord, thrice I have served. I have filed the affidavit of service last, my lord, the Thursday.
No, unless, my lord, police.
My lord, police is
not
playing with
vacated
the
premises,
promoter.
my lord, we.
1 minute.
Then again, pursuant to lordship direction. Again, notice.
Ali, please come. None appears on behalf of the contemptor number 3. Stop. Learned advocate representing the contemptor numbers 1 and 2.
My lord, one to submission, my lord, contender number 2, my lord, Mr. Dibyendu Pal. My lord, now he has changed, my lord. Name, my lord, Brojo Kishore Dhar, my lord.
তুমি তো দাঁড়াচ্ছ কেন? হ্যাঁ, ব্রজ কিশোর।
কি বললাম? Number 3, despite service. Stop. Learned advocate representing the contemptor numbers 1 and 2 relies on the communication made by the executive engineer within bracket civil/building addressed to the officer in charge, Koshwa Police Station. requesting arrangements to be made for vacating the unauthorized building at 45A Bonku Bihari Chatterjee Road, Ward number 67, Boro VII, so that the demolition process can start. Stop. Paragraph there, the court, vide order dated 16th June 2023, directed the Deputy Commissioner of Police within bracket SSD to take steps for vacating the subject structure and intimate the date of vacation to the corporation so that the men and agents of the corporation may remain present at the spot and demolition can continue simultaneously. Stop. Time period to take steps in compliance of the said order expired long back. Stop. The unauthorized construction is still standing. Stop. Next. As the contemnor is not represented, it is evident that the contemnor is not inclined to comply the order passed by the court. Stop. Let contempt rule be issued against
Contempt number 3, my
the contemnor number 3, returnable on 10th April 2025.
Instruction be kept on record. But
There is one communication. Communication kept with the record. Yes.
Can you please Lordship's last order, Mela?
Bhutan.
6th March, Mela.
Yes.
We are producing one, Mela, the regulations passed by the government of India, Mela. In our regulation, Mela, there is no specific regarding the leave encashment rules and replacement, Mela, the leave encashment interest.
You do not follow your own rules.
Mela, we have our rules, but we are following the government rules also, Mela, because it is.
How can that be? How can you rely upon two rules?
Mela, this is the Regional Rural Bank Act 1976, Mela, we have followed. With the with the Union of India, along with the NABARD and Mela sponsor bank and Mela the central government, these rules are forms, Mela. And Mela,
show me the rule according to you.
In terms of section 29 and 30 of the Regional Rural Bank Act 1976, the rule framed by the bank placed before both the houses for approval. After according approval, this has been published in the Gazette, and thereafter it has been circulated by the bank, which is being followed by the bank. So any circular referred by my learned friend issued by the DOPT is not applicable in our case.
Show the law that they follow according to you.
My lord.
What is the law that the bank follows? Show me once. And where is the provision for grant of interest on account of this? CCS rules.
My lord. Last notification that has
You want interest on leave encashment, delayed payment of leave encashment.
Why? Why?
No, is it so?
Leave encashment.
Leave encashment, delayed payment, you want interest. All right.
My lord, why?
Hmm.
My lord, from a perusal of the page 9 of the affidavit of compliance, it would be evident that to protect the interest of the bank, they have deducted a huge amount of interest from the petitioner. Although petitioner was restrained from payment of the loan. Why? Yes. My lord, just 1 month before superannuation, proceeding was initiated, continued, and the inquiry officer during the course of inquiry filed a report before the discipline authority that out of 43 charges.
No, don't go into all these things. Just show me that you are entitled to interest on the CCS rules, on the leave encashment.
Rule is not specific. I must be candid.
Then nothing can be done.
Kindly have a look to the rule first only.
If you say, what is the use?
Had the money been paid, had the money been...
See, you've got interest on the other portion. Leave encashment, according to CCS rules, there is no... You have not been able to show any rule which permits interest on the delayed payment. Then it cannot be done. Please come. According to the bank, there is no provision for grant of interest on delayed payment of leave encashment. Stop. Learned advocate for the petitioner is unable to produce any rule which permits grant of interest on account of delayed payment of the leave encashment. Stop. Next. In view of the above, the prayer of the petitioner for grant of interest on account of delayed payment of leave encashment cannot be allowed. Contempt. The order of the court has substantially been complied with. Contempt application stands disposed of.
Deeply.
Next.
I am for the petition for the added parties. My lord, pursuant to my lord's last directions, my lord,
there was the contempt not being led by Mr. Amit also.
Now, my lord, as per my lord's last instruction, direction, my lord, certain offending portions, my lord, were directed to be demolition. My lord, we've done that, and my lord had.
Who are you representing?
My lord, the person who's made the construction, my lord.
You are the person responsible for making the construction. Who is the authority? Which authority is this?
The Jila Parishad and the P and RD department were directed to conduct an inspection And upon inspection, also a report was submitted before your lordship, which has totally showed that how much part needs to be further needed to be demolished. That has been thereafter
We've done that, my lord.
respondents were directed to take steps for demolition of that portion, lordship.
Did you go and check up?
My lord,
So
that
thereafter, after their
that remains
demolition,
to
we
be
have.
seen what they have done, but they have, your lordship, they have,
my lord, if I may indicate,
from the report, it appears that they have constructed more than double area.
No, no,
of
that I
the-
remember.
Not that
Now,
report, my lord.
They have their own accord, my lord, they have demolished fourth
Top
floor.
portion.
Fourth floor. But this cannot cure.
Yes, this cannot cure the
Cannot cure
error.
the, yes, cannot cure the unauthorized construction.
Yes, this I
No,
can
my lord,
follow.
They are saying that by demolishing that portion, the unauthorized construction may be regularized and or approved by this court. This cannot be done,
my lord, we've
My lord, the
written to
report dated 8th of January 2025. Kindly peruses that report, lordship.
Yes.
That is the latest report, lordship. If your lordship peruses paragraph number Roman 4 of the said report, lordship.
After the demolition being made by the person responsible, no inspection.
That is, my lord, we are praying, my lord, let them make an inspection, my lord. We've written.
Paragraph 4, my lord. My lord, paragraph 4. Paragraph 4. Area demolished with pillars above G+2 level 107.64 square meter. Are not demolished.
On behalf of the parties that certain portion of the unauthorized construction has been demolished. Stop. The engineers of the Nadia Jila Parishad and the Panchayat and Rural Development Department are directed to cause joint spot inspection to ascertain as to whether there is any further portion constructed unauthorizedly beyond the sanction plan contrary to the rules, building rules. Stop. The spot inspection shall be conducted upon prior notice to all the necessary parties at the earliest, but positively within a period of 4 weeks. Stop.
My lord.
Court of spot inspection shall be placed before this court on the adjourned date. List the matter on 8th May.
If I may indicate,
Yes,
my lord.
yes. Necessary parties, including the petitioner.
My lord, pursuant to my lord, the division bench order, my lord, and my lord are also been pleased to hold, my lord, because any further demolition, my lord, will damage the structural stability of that building and the neighboring buildings, my lord.
It is you who did it.
Yes,
you are
my
at
lord, my
peril.
lord, yes, my lord, but
so
perhaps, my lord, that was indicated also in the division bench's order, my lord.
Why will this leniency be shown to you?
No, my lord.
First of all, why? Is there any reason? You are making unauthorized construction and then you take the stand that if it is demolished, the whole construction will go. It is up to you. It's your risk.
No, my lord, the matters proceeded after that, my lord. Perhaps they've not indicated that.
No, they have indicated. I completely remember. Mr. Bhattacharya was there.
Yes, madam.
Then?
Yes. Grateful, Lord.
Grateful, my lord.
Grateful, my lord. Hello, I'm grateful, my lord.
Tulsidas Rai. No.
This is a contempt petition, madam.
Contempt petitioner. Who is this? Krishnendu Bhattacharya?
My lord, I am led by Mr. Krishnendu Bhattacharya.
You are
my lord,
for
last occasion for one of the writ petitioner, my lord, Tuhin Shaha, the neighboring building.
Never
have
took
not
any objection from me. Now
the petitioner Tuhin Shah has not executed any wakalatnama to them. My lord.
But after filing this petition,
Here I see the petitioner is Saraswati Pal.
Yes, but my lord, kindly see all the previous division benches order, my lord.
Division bench, they filed, they say that they are appearing in one of the petitioner. No, taking no objection.
Neighbor. My building is the neighboring building. I will be the.
Are you a party?
No.
Yes, your lordship, in the division benches.
Petitioner.
In this contempt, are you a party?
In contempt, we are not a party.
Then this is a contempt matter being taken up. Why will your submission be recorded? No, it will not be. Yes. Is it appearing for the first time?
Lordship, it is the application, my lord, arising out of.
Oh, it's an application. Yes. What is it for?
Your
ladyship.
Substitution.
Your lordship, may I
On
assist?
substitution.
For Lordship,
Yes, Your
My
Lordship, I
lord,
appear on behalf of the petitioner. This application is seeking substitution of the property which has been attached by ED. This application is through the resolution professional, Your Ladyship. And I'm seeking the substitution of the property that has been attached in that place with the equivalent value fixed deposit that will be deposited, Your Ladyship. Because what they have done, they have attached the factory of the company, Your Ladyship. This attachment is an admitted fact, has
Who
not been
is your
attached as
side?
direct.
Did you serve? Did you serve?
Yes,
Nobody is
we have
appearing.
served. We have served, Your Ladyship. We have served the other
Everybody
side,
has
Your Ladyship.
received. Nobody is appearing.
This is coming up for the first time, Your Ladyship.
First time, but then you have
Yes,
served
we have
since.
served them. Yes, we have duly served them. Your Ladyship may consider issuing them a notice on this and let their reply come. Your Ladyship will advance arguments on this.
Please come. None appears on behalf of the respondents. Stop. Let a fresh notice be issued.
Ladyship may direct them to file reply, Your Ladyship, so that it can be heard on the next date of.
A report be filed by the
Yes.
respondents on the adjourned date with an advance copy to the learned advocate representing the petitioner. Stop. Released on 10th of April. Affidavit of service is
Much
taken.
obliged. Much.
378, 379, and 380. Those three matters are analogous matter and are pending before your lordship for consideration for some times. These three matters can be disposed of today in view of the report submitted by the concerned block land and landforms officer. Your lordships will find, your lordship has also on earlier occasion, the concerned block land and landforms officer has submitted the report by saying that the land in question is the Gratuity land. The Gratuity land is belong to us. The land does not belong to the Vidhannagar Municipal Corporation. But in view of the order to consider the representation made by the private respondent or writ petitioner in their writ petition, the corporation has come and demolished the entire brick wall. Brick wall has been demolished. In view of that, I have also filed a writ petition and also the review application, reviewing your lordship's order and the fresh writ petition, challenging that order of demolition. Those two are there. They have filed one contempt application, which is also appearing in your lordship's. Contempt goes now. In view of the report, contempt now goes. Questions is only this one thing I will show your lordship from the report at page. Your lordship will have a look at the report. Just one page.
Where is the BMC? You are there.
Mr. They submitted this report.
Yes. Pursuant to
BLLRO.
Yes, BLLRO report your lordship will find.
The plot is Gratuity land.
Yes, that page, that is a sketch map. Your lordship will have a look at that.
Yes, a sketch map.
Your lordship will find Vishwa Bangla Sharoni. Thereafter, 138P plot C. Your lordship will find in plot C, and thereafter plot B. Thereafter, tag number 137. Plot C. Your lordship will kindly see the schedule. A passage. Your lordship will find A.
Yes.
Plot C.
No. A. Plot. There
A, I can see passage.
Plot A. Your lordship will find the passage. There is no dispute with regard to that. Your lordship will kindly come to plot B, vacant.
Yes.
This land is mine. In between the C and B, there is a wall. They want to try to demolish this wall and to enter my land, and that demolition has been caused by the Vidhannagar Municipal Corporation. This in between the C and B, that wall. This is the main thing. They want to try to go that number 140. Your lordship will come to that 140 on my land, and for that reason, my wall has been completely demolished. I filed the petition setting aside the order of demolition passed by the concerned Vidhannagar Municipal Corporation, and for that not necessary compensation, nothing else.
No, but then today we are in contempt.
This is not the actual story.
Review goes.
Only
the repetition survives.
This is not the fact what my learned senior friend has submitted.
I am submitting.
Kindly see, dag number 138, 137. blood, all these Dag numbers, the property comprising in Dag number, blood, that part sold out in the year 1980, 1990.
The court is not to look into all these things, right?
Blood, kindly give me a
1 minute. This is a review.
blood, even it is not
Review, I
maintainable.
have filed my lord review
I
application.
am
my lord.
And CPAN.
Yes, blood.
Writ, I cannot hear because I do not have the jurisdiction to hear it, right? This will be a municipality matter. I can see the review and I can see the contempt.
Yes. Blood, the review application, blood, the
Review of this report,
blood, the
contempt
review
goes also.
blood, the review application over the same self cause of action, blood, 3 matter has been filed by my learned friend. One, the review application that my lord has filed. Why the review application? Kindly see.
It is your review, application
Yes.
for review,
I
and
have
the
not-
contempt is yours.
I have
No,
filed
blood,
the review application. my
blood,
lord,
the why review
reviewing your lordship's order, whereby your lordship was pleased to direct the concerned authorities of the Vidhannagar Municipal Corporation to consider and dispose of the application and to act in accordance with law.
Yes.
But in view of
What
this
is
order,
there
your
to review? There is nothing to
It is
review.
that was filed. I am submitting because of
If
that
any
reason.
steps in taken further and there to, that's a
That's why
fresh
I'm
course of
submitting
action.
because the
Commissioner
report
has passed
submitted
the
review
order.
goes.
Co-
In
commission-
view of the sub,
Blood,
Hey,
the
please come.
blood, the
Review
commissioner,
goes.
blood, the commissioner
Only
has
the
passed the
reports are
Learned advocate appearing for the review applicant submits that in view of the report filed by the Blockland and Land Reforms Officer, Rajarhat North 24 Parganas, dated 13th November 2024. The application for review has become infructuous. Stop. In view of the said submission, application for review stands dismissed as infructuous. Stop. It has further been submitted that contempt is yours?
No,
blood, the
controlling
contempt
my
is
learned
fine.
friend, contempt
Yes.
is also blood goes.
No, blood, the
In
con-
view
Oh,
of
wait.
this- Yes.
You do not have to mention anything.
But
Your contempt?
contempt is blood, the violation of the my lord's order. Kindly
Yes.
see, blood, the even there was direction for demolition of the entire unauthorized construction. The
Required.
report which has submitted just right now, my learned friend has indicated. Even blood, from the report itself, there is a blood indication
wall.
that there is a brick wall. The corporation has not blood demolished the entire unauthorized construction. Blood, this unauthorized construction has to be removed.
All right. Please come.
And blood, the order is
appears
page
that
67.
It have a contempt. It appears from the submission made on behalf of the petitioner that a part compliance of the order has been made and subsequent events have taken place. Stop paragraph. The court is of the opinion that the subsequent events give rise to a fresh cause of action and the same cannot be adjudicated in the contempt petition. Stop. Next, in view of the above, the contempt application stands disposed of. Stop. It will be open for the petitioner in the contempt petition to approach the competent forum for relief.
So for the my writ petition is concerned.
Writ petition, this court does not have determination. What is the number?
No, this writ petition is number 9611 of 2023.
Acha, the writ petition
WPA
961123, it's not disposed of. It's pending.
No. This is challenging the order passed by the Vidhannagar Municipal Corporation.
Acha. WPA 9611/2023 stands released from the list of this bench for want of determination. Stop. Liberty granted to the advocate on record of the petitioner to approach the competent forum for relief.
I'm grateful to.
My lord, I am paying for not today, my lord, led by Mr. Loknath Bhattacharya.
My lord, kindly see the communication. Why, my lord, I have not taken step for compliance with your lordship. Kindly call the This is my instruction, my lord.
Communication.
My lord.
Which communication?
My lord, the petitioner has communicated your lordship's order.
All right, page.
My lord, there is no page marking.
No page marking.
My lord, then no, my lord. The last page.
Last page.
My lord. The difficulty has, my lord, that's why, my lord. My lord, kindly see the enclosed page. Finally, here is the copy of the order dated 2nd June 2022. My lord, there is no order, your lordship, 2nd June. Passed by the Honorable Justice, your lordships, along with the copy of the representation. Then, my lord, next page, next paragraph. Hence, I request you not to take any steps on the basis of the order dated such and such, which your lordship's order. kindly page 22, my lord, your lordship's order. Then, my lord, the kindly acknowledge the same, do the needful for compliance of the order dated such and such. And there is no, my lord, the date. And, my lord, there is no advocate sign. Difficulty is, my lord, at the disposal of this writ petition, my lord, no one's appear on behalf of the, my lord, the municipality. That's why we have confused whether firstly, my lord, my office says no order copy has been served.
You are for the Joynagar
My
Mojipur
lord,
municipality.
With that adjournment, my lord, after receiving the contempt, my lord, the contempt application, I advise that's
What
one
was the
order has been
direction?
passed.
What was the direction?
My lord, order, my lord, for consideration of the representation. That is
Only
allotted.
consideration, that also not done.
No, because our difficulty is, my lord, my lord, the client says.
Now has it been considered?
My lord, I have, my lord, received, and in the meantime, my lord, I have, my lord, instructed to comply your lordship's order.
Very
So
well,
I
please
need some more time,
All
my
right.
lord, for 4 weeks.
An accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. Learned advocate for the contemptor seeks time to comply the direction passed by the court. Stop. In view of such submission, release the matter on 15th of May.
It might be mistake here.
Compliance, affidavit of compliance be filed prior to the adjourned date.
My lord.
Yes.
My lord, I am appearing on behalf of the petitioner, my lord.
Order complied?
No, my lord.
No.
Because of that, one of the tenant, my lord, filed one deed petition before the.
My
My lord,
that
And
is
stay has
lordship
been-
pass-
no, he is in online. My engineer is in online.
Who is online?
One order was passed. my
One
lord.
order, your lordship
for a
passes the order on
stay.
16
For a
January.
period of 5 months, my lord,
All
on the
right.
basis of
No, I
undertaking
am
given
placing
by
her.
the petitioner.
16 January, your lordship passes the order. This order to comply it. But at that time, I was not aware of the order. This is an order by the other bench. We have taken restrain us that for 5 months, within 5 months, they will vacate and demolish it themselves.
All right.
That is there.
On the basis of that
On the
undertaking,
basis
my
of
lord,
that undertaking, my engineer submitted the order, and for that reason, even then also, he is in online. Patient.
Very well.
He is in online. He has
5
already
months
made
from
an
date
inspection,
till May.
12 of
and
Very well,
vacating
please
notice
come.
has been given, my lord.
but keep it after
The
12
executive
of May.
engineer,
After 12 of May,
executive engineer,
OSD demolition, my lord. OSD demolition.
comma diye, OSD demolition, Howrah Municipal Corporation is virtually present. Stop. The order dated 12th December 2024, passed by a coordinate bench of this court in WPA 10847 of 2024, within bracket, Kashinath Ghosh versus the Howrah Municipal Corporation and others, has been placed before this court. Stop. Next. The
personal appearance be dispensed with.
in view of the order passed in the matter of Kashinath Ghosh Supra, hearing of the contempt application stands adjourned till 12th June 2025. Stop. An updated report shall be placed before this court on the adjourned date. Stop. Personal appearance of the executive engineer is dispensed with for the time being.
My lord, 5 months expire on 12th May.
Yes, 12th May.
Yes.
So it has been directed to appear on 12th of June.
Great.
Yes.
I am appearing on behalf of the petitioner.
Man, I am placing the report.
Pursuant to your lordship's direction, my lord, part demolition has been.
No, part. What demolition I am stating, my lord. The third, fourth, and yes. Third, fourth, and fifth floors are being demolished. This will take some time, my lord. I am placing the demolition pictures also because your lordship directed me.
Yes. Have you brought pictures?
Yes, my lord, I have.
Let me see. Please come.
This is telling with their pictures also, my lord.
All right.
Because the third,
Report
fourth, and
of the
fifth floors are
assistant
demolished, my lord.
engineer within
But it
bracket
will take
Building
some time.
Department, Howrah Municipal Corporation, dated 12th March 2025 is taken on record. Stop. Photographs produced by the learned advocates representing the
Both the
respective
sides.
parties are also retained with the records.
I may go through their photographs also.
It
will
appears
show.
that the demolition process is on. Stop. Learned advocate for the contemptor submits that the demolition will take some time. Stop. Next, in view of the above, the contempt application is adjourned till 12th June 2025. Stop. An updated report shall be placed before this court on the
Both are
adjourned
12th
date.
June. Grateful,
Both
Your Lord.
12th.
Grateful, grateful.
84. My lord, 384 on behalf of Sudeep Kumar Pusari, I paid for only not today, my lord. He has not come to the personal difficulty, he has not come.
Order complied.
Order complied, but certain exception petitioner willing to. And my lord, that is order has been passed. Decision order has been passed. Petitioner disputed with the order. Now taking time.
My lord, I appear for the applicants in the writ petition, my lord, lordship, because the construction belongs to me.
You appear for the applicants?
Yes, we made an application for additional party. My lord is pleased to hear us. Your lordship will find our names also recorded in the writ petition, the order.
Yes.
Now, my lord's order was that the matter will be heard and the corporation will hear out, my lord, and pass rescind order. Now, a rescind order has also been passed after hearing my client. And it's recorded in the order also, if I find that twice or thrice when the matter notices were given to the writ petitioner, on all occasions he was absent. The order was passed upon hearing my client. And my lord, what was found is that the basic allegation that my client has constructed, or rather Sri Krishna Purua, from whom I have purchased the property, he has constructed on the house on RS plot number 540 is incorrect totally. Because the section plan of the municipality.
An accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. In view of such prayer, released on 3rd of April.
Not true.
Contempt application. So despite of your lordship several addiction, it is not comply with your rights.
Where is the Bidhannagar Municipal Corporation?
So the last order was passed on 16 January. 16 January 2025.
Police assistance given or not?
Well, we had asked for the police assistance, but we do not know whether there is information. Just the 25th of this month, we have sought for police assistance so that it can be demolished.
You knew the contempt application is returnable on 13th.
There was communication because there are a lot of directions for demolition, and we have been continuously. If we produce Millard will see that every day there is some demolition of the other.
That means the amount of neglect your officers are doing in their work and permitting these unauthorized constructions to come up.
To correction, Millard.
No.
These unauthorized constructions are of maximum are of time period before the corporation even came into existence.
Right. This is the only way you are trying to wriggle out of the contempt situation. But here the order was passed by your commissioner, the corporation's commissioner, not that the earlier authority passed order. It is you who passed order of demolition, and you are being unable to implement your own order.
Not this matter, Millard. I'm saying that the matter there are.
I have followed it.
But by 25th, Millard, it will be done, Millard.
Learned advocate for the contemptor submits upon instruction that request has been made before the Commissioner of Bidhannagar Police Commissionerate to provide police assistance on 25th March 2025 for demolition of the unauthorized construction. Stop. Paragraph. In view of such submission, hearing of the contempt application stands adjourned till 3rd April.
For the necessary compliance, Millard.
Yes. An updated report shall be placed before this court on the adjourned date. Next.
386. I am for the petition.
Yes.
For the alleged contemptor, director of local bodies. My instruction, payment of gratuity and arrear with interest has been paid.
Paid.
May I submit?
Order complied. Disposed.
386,
87,
388,
up to 90.
389, 390.
All complied.
All complied.
Thank you.
And my lord 403,
Thank you.
413 and 415.
1 minute. Are you there in those matters also?
Up to 90.
Up to 90, all complied, disposed.
It is-
And 403 also, you are there?
No,
Yes.
No, somebody else is there.
No. I was there. My instruction is not with me.
Alright, ঠিক আছে। 391, 390 পর্যন্ত সেম অর্ডার। কোত্থেকে শুরু হলো? 386 থেকে 390। Order of the court has been complied with. Disposed. Both parties বলছে কিন্তু।
না 413 গুলো রবি হাজার সবকটাই সুব্রত ঘোষ মিউনিসিপ্যালিটি কর্পোরেশন মিউনিসিপ্যালিটি
391.
391, my lord, Mr. Arup Krishna Das is appearing. I'm praying for just very short password. Just he's not coming, my lord.
Passover is very difficult. What you are for? Petitioner?
My lord,
And he is for?
He's I'm leading by Mr. Arup Das, my lord.
Very well. You make your submission.
My lord, on the last occasion, my lord, your lordship was pleased to direct to sub copy upon the learned government pleader, my lord. I have served. This is the everybody serving, my lord.
Where is the service upon the government pleader? You send it through post?
My lord, they have refused to accept because someone was appointed in this matter.
Where is he now?
My lord, that is why, my lord, I have served.
What that is why? Mr. Dev, please see. Please come here. Hand over a copy. None appears on behalf of the. Which contemner will it be?
My lord, chairman of the Municipality Municipality.
No. Why was state directed to be served?
My lord,
in the earlier occasion, your lordship directed the advocate who appears to appear for the BLLRO.
BLLRO. Who appeared for BLLRO?
Lordship directed to serve upon what is the number for the
Shondip
Mondal, my lord.
Joita Sinha and Shondip Mondal.
Lordship.
They are not appearing.
Not appearing. Then lordship directed to serve upon the office of the government pleader who duly served.
Did you intimate the learned councils?
At that time, my lord, yes.
And they refused to accept?
Refused to accept, saying you are not in this matter. Then he served a copy upon the GP office.
GP office through post? Your next door neighbor, you'll serve it through post?
We went there. The concerned person told us, served upon the learned advocate who has been directed. We proposed them to get it.
Anyway, please come. None appears on behalf of the Block Land and Land Reforms Officer. Which place? Which Block Land and Land Reforms Officer?
Contempt application. Contempt. Or just taking contempt.
See, BLRO was not a party in the main writ also.
Yes, my lord, not a party. And for submitting, my lord, his presence is not at all necessary because
the presence is not necessary.
Not at all necessary because here we are alleging that some unauthorized construction is made. Now they are saying demarcation is necessary where that construction has been made. I fail to understand what is necessary of BLRO for measurement for demarcation of the land because unauthorized construction is there. They serve stop work notice in spite of the construction erected. Now they're taking the plea that demarcation measurement is necessary to identify the plot. What is necessary to identification?
So state's presence is not required, you say?
Not required at all, my lord.
Then it is all right. Yes,
I'm
municipality.
for the alleged contemner, my lord. My lord, this was the second round of litigation. In the first round of litigation, my lord, allegation was there that the unauthorized construction was over a plot of land which was identified by LR and RS Dag number. Thereafter, the corporation, the municipality was directed to make an inspection of the property and identify the unauthorized construction. The persons went there, could not identify the plot. Even the petitioner could not help the persons engaged by the municipality to identify the plot. Thereafter, he came up with a second round of litigation. Now he says that the unauthorized construction is made over a plot of land with a specific premises number, giving a specific premises number. Thereafter, again, the persons engaged by the municipality went over there, but the unauthorized construction could not be identified. He is not annexing any photograph of the unauthorized construction also.
My lord, absolutely. May I submit, my lord? Can you see page 75 of the read petition? For a moment. 75 of read petition.
Yes.
Can you see the
My
scope
lord,
of notice?
Since the
This is
plot,
another
since the
construction, my lord.
unauthorized
What you are
construction
saying, my
could
lord,
not
I
be
don't understand.
identified, my lord,
Scope
the
of notice is issued, my
chairman
lord.
of the municipality.
Where is the photograph of the unauthorized construction? Bring one photograph so for the municipality to identify it.
I can. Can you figure it? Because they've already issued stop of
My lord,
notice.
is it
Now they are saying
possible
it
in
can be
the
identified.
contempt jurisdiction, my lord? Now, after the writ petition has been disposed of.
And furthermore, my lord, when you filed the first
Page
petition,
75, you have issued a stop work notice.
Lordship.
How could you issue till you can identify the unauthorized construction?
My lord, that is why we wrote a letter, the chairman of the municipality wrote a letter to the BLRO to make an inspection.
So prior to identifying, you issue a letter that unauthorized construction is going on. If this is your stand, you cannot identify, then how could you issue the notice of stop work? You cannot, isn't it? Once you issue a notice, that means you have been able to identify a structure where unauthorized construction was going on. Then how was page 75 issued? And now you take up the plea that you cannot identify it? You take the help of the BLRO and you go to the DLRO and to the ADM? What is this? How come page 75 come into existence? Please come. Learned advocate representing the contemptor submits that the unauthorized construction could not be identified. Stop. It appears that the Board of Administrators of the Bashpedia Municipality had issued notice to one Dhananjay Chatterjee requiring him to stop construction as the same commenced without sanction of the building plan and in breach of the provisions of the Municipal Act. Stop. The present submission of the contemptor that the unauthorized construction cannot be identified appears to be made out of desperation. Stop. Had the construction not been identified, then the stop work notice could not have been issued. Stop. It is only after the unauthorized construction was noticed that direction was passed upon the person raising such unauthorized construction to forthwith discontinue the construction. Paragraph. The municipality is directed to take immediate steps to comply with the direction passed by the court and file affidavit of service on the adjourned date. Stop. Released on 17th of
My lord,
April.
affidavit of service or
Affidavit of compliance.
My lord, previously an affidavit of compliance had been filed, my lord, by the
Where you said that you could not identify.
lordship.
Now, if you cannot do, I'll summon the entire board to be here. Yes, call.
Deeply obliged, my lord.
Well, I am
392.
appearing on behalf of the municipality, my lord.
Yes.
Order of this honorable court has been complied with, cost has been paid.
Where is Mr. Mahato?
Yes, my lord.
Jiaul Haq, yes. Geotagging, show me.
My lord, today, my lord, Mr. Mahato missed the brief, my lord. So,
You do not have any photographs? Geotagging photographs?
my lord, it is with Mr. Mahato, my lord. My lord, kindly make it not today, my lord, next
Very
day.
well, not today, next week. On the prayer made by Mr. Ziaul Haq, learned advocate, representing the Divisional Forest Officer, Hooghly. Hearing of the matter stands adjourned till 27th. Stop. The evidence shall be produced by Mr. Haq to show that the plantation in question has been made, and the evidence of geotagging of the same shall also be produced before this court on the next date. Next.
393.
393, my lord.
Yes, what is it?
Complied with, my lord. Plantation has been done.
Plantation done.
Yes, my lord.
And what is the
This is the photographs, my lord.
photographs? Are the trees
Photographs
growing?
and the compliance report.
Trees are growing?
Yes, my lord.
Or they have been eaten away?
No, no, my lord.
They are growing?
What photographs are there?
Photographs are there.
Barricade is there also.
When were the photographs taken?
This is the report, my lord, dated
date
2nd September 2024.
So by now the trees must have grown a little bigger. Let us see. Bring the photographs. Acha, ashun to dekhe. Peruse the report filed by the Divisional Forest Officer, Purva Mendipur Forest Division, dated 2nd September 2024. Stop. Photographs of the subject plantation have been annexed with the report. Stop. Let fresh photographs be placed before this court on the adjourned date. Stop. The photographs shall be taken in such a manner so that the plantation, so that the status of the plantation is clearly evident therefrom. Released on 15th of May.
Thank you for yours. 94 same as 93. Compliance report is there.
देखिए देखिए
This is also 2nd September 2024.
Please come. Report of the DFO Purva Mendipur, 2nd September 2024. যে আগেরটাতে যা ছিল written with the records. ঠিক আছে, ওই আগের অর্ডারটাই করে দিন. Bring fresh photographs.
Foreign advocate Mr. Ijaz Hussain is appearing, Lord, although my lord, he came to court and left the court not for his mother's illness, I am appearing.
Yes.
My lord, last occasion, Your Lordship directed the to see the actual state of affairs, my lord.
Whether unauthorized construction exists over government plot of land.
Yes. It was communicated, a spot inspection made. I don't know whether any.
Are you there?
Report is there, my lord. I am appealing for the BLLRO, my lord.
Yes.
Pursuant to my lord's direction.
What is your report?
My report
Give
says,
a copy.
my lord,
Give a copy.
My report says, my lord, there is no, my lord, government land. There is no structure on the government land. And the subject plot is, my lord, the plot numbers 752, 753 and 51, a private land. There is a government land, but there is no such kind of structure is there, my lord.
Very well.
And
A report of the Block Land and Land Reforms Officer Horipal Hugli.
photograph is
Signed on 13th of March 2025. Filed in court today, is written with the records. Stop.
11 photograph.
Copy of the same. Handed over to the learned advocate for the petitioner in court today. Stop. Release the matter on 27th March. Instruction shall be obtained by the learned advocate for the petitioner prior to the adjourned date.
My lord, since my lord, we are appearing pursuant to my lord's earlier order, if my lord kindly direct to regularize our name, my lord, because we are appeared in the writ petition, but not in the contempt, my lord. But pursuant to my lord's direction, we came with the report, my lord.
The court passed order to
Yes,
serve you.
my lord. Last occasion, my lord.
দেখি কি অর্ডার আছে দেখি দেখি ফাইলটা দিন না
Order dated, my lord, 30th January, my lord. I am appealing, my lord, led by Mr. Sushomon Sengupta.
January, there is no direction to serve
My lord,
notice upon you.
Serial number 3, let notice be served upon the learned advocate representing the state respondent in the writ petition.
Yes.
The BLR Horipal is directed to
Right.
conduct. Yes, my lord. And pursuant to the same, my lord, we appear, my lord.
And you intimate your GP's office?
Yes. But they have served GP office. GP office instructed me.
Then they should have been regularized by the GP office itself.
They have not regularized, but my lord, they just communicated the letter to us.
You seek for regularization. In case of any difficulty, remind me. I'll regularize it.
My lord. My lord, report submitted, my lord.
Exception to the report, if there be any, may be submitted in.
Exception to the report may be filed prior to the adjourned date.
Okay.
Next.
My lord, there are two contempt petitions.
Yes.
One of them, my lord, is mine. If your lordship takes up my contempt application for a moment.
What is the number?
CPAN 1180 of 2024. CPAN 1180. Now, my lord, I only wish to place two orders, my lord, before your lordship. One is at page 44, order dated 12th April 2023. And the other is at page 47, order dated 12th May 2023. But kindly take, my lord, at page 44.
Yes.
Now, my lord, your lordship will see, my lord, I'll just give a 30-second background, my lord, in which this order was passed. My lord, there is a old...
Come to the operative portion, please.
Yes, your lordship will see, my lord. Come to page 45.
There was a direction for spot inspection.
Yes. No, my lord, kindly see the petitioner, my lord, refers... Kindly see page 45 for a moment. Learned advocate appearing for the petitioner admits that only a hole has been made in the roof of the building, but the rest of the building is still standing. The petitioner refers to electricity bill so-and-so. The learned advocate appearing for the Havra Municipal Corporation submits that the unauthorized portion has been demolished. Kindly mark this submission of the Havra Municipal Corporation. So the corporation said that the unauthorized portion has been demolished. G+1 old 60 years old structure. On top of that, there was some work done on the terrace. That was demolished. Now, my lord, kindly now, my lord, see, take page 47.
Yes.
This is the order by which your lordship disposed of the writ petition. Your lordship will see the order, my lord. The operative part, my lord, at page 48, kindly see the second paragraph onwards. The petitioner asserts that the unauthorized construction is yet to be demolished. The aforesaid submission of the petition is denied by the learned advocate representing the private respondents. Photocopies of the demolition have been produced by the learned advocate representing the Havra Municipal Corporation. It appears therefrom that demolition to some extent has taken place, but the private respondents are using the said portions with temporary plastic sheet. The Havra Municipal Corporation is directed to ensure that no unauthorized construction is raised at the said premises. This is one of the direction. The officer in charge is to keep strict vigil over the property. Now, since the date of this order, not an inch has come up on that property. The old structure, which is 60 years old, and I have documents to show this has been there for at least more than 40 years, G+1. On that, yes, my father, late father, did make some unauthorized construction. That has been demolished, demolition done. I have suffered the demolition, papers shown to the court. It's been recorded by the corporation that demolition is done.
What is your contempt?
Now, my contempt is that, this order of your lordship does not direct any further demolition. Now, kindly, take, page 52.
No,
Kindly, please, you take your turn, sir. This is a serious matter.
Please do not behave in this manner before the court.
I'm sorry, my lord.
Try to maintain decency.
I'm very sorry about sometimes we get carried away. I'm very sorry.
No, please don't.
No, I'm sorry, my lord.
Yes.
My lord, page 52.
Yes.
Kindly take page 52. This is an order of 3rd July 2024. My lord, this was served upon me.
Yes.
In reference to the order and judgment passed by her lordship, the Honorable so-and-so, on 12th April 2020. This is the first order, interim order that I showed your lordship. And subsequent order of the commissioner so-and-so, a program for demolition of the unauthorized G+1 story building has been scheduled on 11/7 so-and-so. So, my lord, your lordship's order in the writ petition only directed that no further construction will come up, and there was a vigil to be, my lord, given.
Does this mean that the whatever unauthorized construction is there to be retained?
May I, my lord, point out the unauthorized construction, my lord, is of the year 1955. I am
now
not
you go
even
to 47 also.
No, no, my lord, there is an immunity. My lord, there is law to the effect that if under the old act of 1950 for 12 years, if no action is taken on an unauthorized construction, there's a deemed sanction and action cannot be taken. This is settled law. In view of this law, my lord, a coordinate bench has granted stay on the action which was being taken, my lord, by the corporation. That stay has been extended till 30th April 2025. There's also been a further inspection done by my special officer appointed to ascertain whether in the premises there is any new construction remaining and to distinguish the old from the new. A report has been filed which says that most of it is old construction and the new construction has been demolished by and large, save and except for a small minuscule portion, and we have been given liberty to file an exception to justify whether they should be retained or not, and that we are in process of filing our exception, and the order has been stayed till the 30th of April. This is where we stand. I'm humbly saying that action, this action which is being taken, is in exercise of powers beyond what your law. The corporation on its own, can do what it wants and we'll respond to it in accordance with law. But to do it, under the guise of implementing an order which never really directed for any demolition work to take place. It said no.
Yes, I followed it.
This is the matter.
Who is the writ petitioner?
He's my first cousin who filed a suit and wanted not to be dispossessed from the property. Not having gotten orders in the suit as a vindictive measure.
What is
he now wants the entire house to be
What is the name of your client? Amit Sonkar.
No, my lord.
You are Munna.
No, my lord. Yes, I am my lord Munna and the others. Munna, I am Rinku.
There are two contempts. One by Munna and another is by Amit. Who are you representing?
So, my lord, I am for Amader K.
Rinku Sonkar, Anand Sonkar, Sam Sonkar, Papu Sonkar, Lalu Sonkar.
CPAN 1180, that means Amit Sonkar. Where is this?
1180 is yes. Amit is my client.
CPAN 46, Munna Sonkar, is anybody representing?
No, today no one is representing. I see.
No one is representing. What is your submission?
My submission is that we have completed the demolition. Already done it. But so far as my learned brother's submission is that we cannot do any demolition.
No, that is gone. You say you have done.
I have done.
And the one who was complaining it has not been done is not appearing. Please come.
So let it be dropped, my lord.
Yes.
I'm so grateful.
The petitioner in CPAN 46 of 2024. Now, likun none represents the petitioner in CPAN 46 of 2024. Stop. The learned advocate representing the contemner, comma, the corporation submits upon instruction that the unauthorized construction has been demolished.
As far as practicable.
As far as practicable. Paragraph. The learned advocate appearing for the petitioners in CPAN 1180 of 2024 submits that the corporation ought not to carry out any further demolition work.
28
Stop. Be that as it may, as it appears that the petitioner in CPAN 46 of 2024 is not represented today, comma, the contempt application stands dismissed for default. Stop. CPAN 1180 of 2024 stands disposed of as according to the corporation, comma, the demolition work has already been carried out as far as practicable. Next.
My lord, in the other contempt petition which your lordship is dismissing for default,
yes,
the prayer was that they should demolish the entire building.
Whatever. It's dismissed for default. Nobody is appearing.
I'm sorry, my lord.
As the same property, my lord, we have already done it. I think there remains nothing, my lord. Let
it be dismissed. Let them come and say if they want to say anything.
I'm sorry for my behavior.
Please.
I'm very, very sorry.
Be conscious. Application 1 call karun.
Malad is taking 415 matters.
415, it's 415 already.
My lord, only one thing, my lord, prior to your lordships takes up that matter, my lord.
Which matter?
My lord, the 415 matters as your lordships has been pleased to indicate in the list. My lord, from 427 to 439, there were matter relating to employees of Purulia municipality who were not getting their dues. My lord, if in that matter your lordship could give some precedence, my lord, for the next week, my lord, I humbly beseeching your lordship on that aspect.
Who is your other side?
My lord, Mr. Shogoto Mitra was appearing.
Bring him.
I believe he's left the court. I tried.
I do not know. If you bring him, I can take it up immediately.
But in item number 399, his lordship has directed the Pradhan to comply with this lordship's order for demolition. But in the meantime, a appeal has been filed and stay order has been granted in 399.
Well, the matter is not being taken up today.
Lordship.
Grateful.
Bring your other side.
In this matter, your lordship, I beg to appear for the petitioner, lordship. Lordship, by an order dated 17th day of August 2022.
Is it appearing for the first time?
Yes, lordship.
Who is the contemptor?
Lordship, the contemptor is... The Commissioner, Howrah Municipal Corporation.
Commissioner, Howrah Municipal Corporation.
And the personal officer, Howrah Municipal Corporation, lordship.
What has the personal officer got to do? What was the relief?
After the order being passed, the entire hearing
On
before the concerned department was taken by his...
Mr. Shondipan Banerjee was here just now. Acha, serve. This is a matter of a widow.
Lordship.
Acha, do one thing. Make it on 10th of April.
Lordship, one
additional copy upon Mr. Shondipan Banerjee, learned advocate who represented the corporation in the writ proceeding.
Lordship, one more indulgence, Lordship. Lordship, there are 3 typographical errors in my petition.
What is it?
I am praying for a leave to correct them. Lordship, page number 12, paragraph number 4, line number 3, order dated has been wrongly typed. It should be typed as 17th day of August 2022. And page number 11, paragraph number 3.
Page number 12.
Paragraph number 4.
Paragraph number 4.
Line number 3.
Line number 3.
Solemn order dated, it should be typed as 17th August 2022. It is wrongly typed. And Lordship, there are 2 others also.
1 minute. Paragraph 12. Page 12, paragraph 4, third line. It should be 17th August 2022. Leave granted to amend. What are the others?
Lordship, page number 11, paragraph number 3, last line. Same error.
Page number 11, paragraph number 3.
3, last line.
You've copied and pasted it from somewhere else. Next.
Lordship, paragraph now, page number 15, paragraph number 12.
Number 15, paragraph number 12. Leave granted
Typed
to
as Honorable
correct
Justice
এই
Shubhra Ghosh,
জায়গাগুলো।
typed as Honorable Justice Amrita Sinha.
Paragraph 12. Name of the judge will change.
Lordship.
And are you aware whether the contemners have changed or not?
No, contemners have not been changed, Lordship.
Call the next
I'm
one.
apprised.
For the petitioner, Lordship. It's a first time contempt.
First time?
Lordship. Against the
Bidhannagar Municipal Corporation serve. It will be on 8th of May.
Grateful, Lordship.
But other contempt matters
Released.
complied already.
Which one? Is your other side here? Bring your other side.
101, your lordship knows that matter, my lord, where payment was, appeal was taken out, appeal was dismissed.
Bring your other side. I can dispose it off. Who is your other side? Make a phone call. If he comes, I can dispose it off.
I can.
398, my lord.
1 minute. Let me finish these matters. Then I'll hear you. 561.
First time appearing.
Very well, serve. 8th of May.
I beg to appear on behalf of the petition. This is for the first time, my lord.
Serve. 8th May.
My lord, the next date.
8th of May.
Petitioner lordship, the first time appearance lordship, kindly see the drainage lordship. Client is also here lordship.
Yes. What is there?
The current picture of the, as per your order lordship,
Huh?
they did not clear the drainage lordship. Kindly
They
see
did
the-
not clear the drainage.
lordship, kindly
Who
see
was
that.
supposed to clear it?
KMC lordship.
KMC.
Kolkata Municipal Corporation. The first time appearance lordship. As per your order, he should not complain. Client is here lordship.
You serve, right?
Lordship.
Diye din ferot. Yes. Yes.
Madam, for the petition of 564, first time.
Serve.
565.
But I am for the petitioner. It's also first time appearing in the list.
Please serve.
566.
Serve.
567. I am for the petition of mine. It's the
First time. Serve.
8. Madam, I am for the petition of the first time.
Serve.
9.
I'm for the petition, my love. It is first time, my love. May seek your kind leave for a small correction in the front page and back page. I have wrongly typed 2024 instead of 2025. Plus.
Where will leave granted to correct the
Grateful.
case number, year of the case
Yeah.
in the front sheet and the back sheet. Do it here and now.
Yes. Grateful.
My lord, in this matter, I am appearing, my lord, first time, my lord.
But I am for the alleged contempt only, sir.
Alleged contemptor.
The municipality, my lord.
How could you get only seeing the list you have appeared?
Yes, my lord.
Where you will give an additional copy to him and serve upon the municipality.
571.
My lord, I am for the petition, my lord, for the first time.
All right.
I appear for the petition, Lordship. First time, Lordship.
My lord, I am for the petitioner. This is first time. My lord. Lordship, I am appearing on behalf of the petitioner. Lordship, this is the first time appearing.
All right. Serve. Yes. What were you mentioning?
With regard to item number 3898, my lord.
Hmm.
98, my lord. Mala, I have already prepared an appeal against your lordship order, my lord.
Hmm.
That has been stayed, my lord.
Hmm.
But due to my lord certificate copy, I have already applied. That has not been taken because due to matter is pending, my lord.
Yes.
So your lord.
The appeal court is there to take care of it.
So my,
Direction for departmental to get obtaining certified copies.
otherwise, my lord, it is not
Otherwise,
possible.
they could not dispose of that thing.
They cannot dispose of the appeal.
No, but they want the certificate, their lordships want the certified copy of that order.
Show me any order passed by the division bench.
That is today itself, it was listed.
আজকে?
It was listed.
It was listed until number 8, my lord.
Item 8 of portal number 26.
ফাইলটা তাহলে নিচে নামাতে হবে। Which item you said?
398.
Item 8, portal number 26.
Oh, here which?
398.
398. Where is the petitioner?
Petitioner was there. And they gave the undertaking that today they will not place these things.
No, it has not been taken up also.
Yes.
So you have to bring your other side. See, the file has to be. ঠিক আছে চল।
I'm good.